Absolutely.
Yes.
My lord, item number 40, my lord, it has become infectious.
Mr. J.I. Bolgunia, the learned counsel appearing on behalf of the petitioner, has become infructuous. Accordingly, the writ petition, interim orders, if any, stands vacated. As Puru appears on behalf of the state of Assam.
Yeah, please, lord. This is a pending matter. Pleading has already been completed, my lord. Can it be on 31st, my lord?
For what?
For, let's say, orders admission, my lord.
Second,
2nd of August. my lord.
It is, Your Lordship. I beg to mention item number 23, Your Lordship. We
20?
filed a 23, Your Lordship.
3.
We filed a reply to against the additional affidavit filed by respondent number 4, Your Lordship, today. Lordship may kindly call for the records.
For what?
As and when the matter comes up, Your Lordship.
You have filed a reply.
Yes.
You want to bring on record.
Lordship, that matter, Lordship, I need 7 days time, Lordship. I have received the copy yesterday, Lordship.
Which one?
Item 23, my Lord.
Let the matter come up during this year.
Let a matter be reached.
Lordship.
We'll see.
Lordship, with the consent of the other petitioners, my Lord, I beg to mention item number 26, my Lord. In this case, I am praying on behalf of Mr. Didas, Lordship. He is unwell, Lordship. So at least 2 weeks time may be given, my Lord. 26.
What is the matter about?
So the matter relates to a land dispute between the parties, between the petitioner and the respondent numbers 9 and 10. They are alleging that the respondent numbers 9 and 10, 8, 9, and 10 have illegally constructed certain shops on the land which the GMC of that particular district has allotted to their name. That is the contention in the writ petition. In fact, Lordship, there is already an earlier writ petition which was filed by them, which was dismissed on withdrawal by the petitioner. I am appearing for the respondent number 8. Your
I am
Lordship.
appearing for the
No adjournment.
I am appearing for the petitioner, my lord. In this case, your
It's a civil dispute.
actually, my lord, what happened, my lord, in a fair
We'll
allotted.
see when the matter is called.
Please, my lord, prayer for requisition of additional affidavit file. Two, my lord. Two. One we have filed as the petitioner and one filed by the respondent number 6, item 51. Highly obliged.
Hello, with the consent of the petitioner's counsel, I beg to mention item number 25, my lord. It's a eviction matter from the railway line, my lord. I have received the instruction, my lord. I have to file affidavit, my lord.
This is for?
For eviction from the railway line, they are already in my lord, interim order is there, my lord.
No, it's a railway line, so is it done under the public premises?
My lord, my lord, we have received the instruction just
We'll see.
will file the affidavit, my lord.
We'll see.
My lord.
May I, Your Lordship? Item number 4, filed IA that may
We'll see when the matter is called.
This matter for motion I have filed yesterday, my lord. Regarding my lord, the time extension to the time of the AGM of the cooperative society, my lord, due to the current wave of flood in the Dubi district, my lord, the particular place, my lord. So may I pray for listening to my lord? If
What? Unlisted? Motion?
On procedural. Okay, please, Your Lordship. The subject matter has been infectious.
I got order to DDP. Same order if any stand. Why it has become infructuous?
The petitioner has been already get the amount.
Petitioner having received the amount for which the instant writ petition was claiming which the instant writ petition is filed, Mr. S.I. Akant, the learned counsel appearing. A. Bhachaji appears on behalf of the Revenue Department, on behalf of the state. Accordingly, the instant writ petition stands closed in time order if any stand.
Number 2, procedural. Also, my second. If left.
Yes, what is this?
Please, Lordship. My lord, there, in the last occasion, question of maintainability was raised, my lord. In the last occasion, my lord, question of maintainability was raised, my lord. Facts are like question of maintainability, my lord. So-called was issued to the petitioner, my lord. Thereafter, my lord, personal hearing was fixed, my lord. On that day, petitioner appeared, my lord, and submitted his reply. Thereafter, my lord, adjudicating authority changed, my lord. New adjudicating authority came, my lord. He issued fresh hearing notice, my lord. On that, the person could not appear, my lord, because of wrong noting of date, my lord. He appeared on next date. He was assured, my lord, that as per practice prevailing, my lord, 2 more opportunities will be provided, my lord. However, no opportunity was given and order was passed, my lord. That's why I've come appear, my lord, because this court seeking one chance to for hearing, my lord. Lordship, the order is at page 48, my lord. My lord, may kindly come to page 50, my lord. Page 50, para 2.0, my lord.
You have issued a demand come show cause notice.
My lord, that was issued, my lord.
Then against that, you submitted a reply.
And thereafter, my lord, hearing was fixed, my lord.
You submitted a reply.
Yes, my during the course of hearing, I submitted a reply, my lord.
Then what happened?
Thereafter, my lord, the adjudicating authority changed, my lord. New adjudicating authority came, my lord. And he issued a fresh notice, my lord.
Huh?
Firstly, my lord, so-called was issued. Thereafter, my lord, hearing was fixed. On the date of hearing, my lord, petitioner appeared and submitted his reply. Thereafter, my lord, authority changed, new authority came. The new authority issued fresh notice of hearing, my lord. On that day, petitioner could not appear, my lord, before the authority. He appeared on the next date. He requested and he was assured that as per practice prevailing, my lord, 2 more opportunities will be provided, my lord.
What practice prevailing?
And whenever, my lord, the authority changed, my lord, new authority came, he used to provide 3 opportunities of hearing, my lord.
Where? Where is it?
And I have some instance of other,
No instance business. Is it a written law?
my lord.
Is it a written law?
Lordship. One more thing is that, my lord, on the previous date of hearing, my lord, petitioners appeared and he has submitted his reply, my lord. That reply was not considered at all, my lord. They proceeded as if there was no reply in the record, my lord.
You were heard on 29/3/2023.
Yes, my lord. I was hired on 29, my lord. On that day, I submitted a reply also, my lord, during the course
So,
of hearing, my lord.
How many hearings you are required?
Thereafter, my authority changed, my lord.
Absolutely nothing. Go there, file an appeal.
My lord, kindly see only one thing, my lord.
File appeal, file appeal. You have anything out there that you were heard on this date? It was categorically mentioned in the impugned order.
Yes, my lord. At that time,
Then-
admitting.
You were heard on how many times you will be heard?
Authority changed, my lord.
Authority change when?
It is written there, my lord.
When?
In the second paragraph, my lord. On the change of adjudicating authority, my lord.
Yes, Mr. Kyle.
Lordship. Lordship, please to page 50.
That is what I am looking into.
Yes. Lordship, subpara 2, on change of the adjudication authority where the undersigned was assigned the task of adjudication, the SCN, and another opportunity of personal hearing was given, granted on 17/1/24. But neither did they appear for hearing, nor did they give any written submission. But earlier, Lordship, they appeared, they've submitted their written.
And earlier he appeared,
Yes.
but here he had not appeared. So give him an opportunity. Matter ends. Unnecessary dragging the matter would not solve any problem. He will file an appeal. He'll take that ground again. The matter gets remanded
But
back.
this point has already been decided by your Lordship, that was affirmed by the division bench also.
Which one?
This issue, Lordship, this is the order.
Oh.
This was affirmed by division bench. This order was challenged before the division bench, and division bench affirmed that order.
No, there is no quarrel with the proposition that there is an appellate tribunal. They can very well file an appeal. There's no quarrel with that. And the matter is attained finally. That is not the issue. But here, admittedly, there is a change of authority.
Yes, Lordship.
That was not the case in that case. There was a change of authority. Here, hearing was done. There was a change of authority on 17/1/2024. Some opportunity was given to him. He did not appear on that day. So, if it is not so, he will file an appeal. He will take up the same ground.
That is there.
And again, the matter will be remanded back. Nothing else.
But Lordship, this practice is going on in every case. This type of practice is going on in every case. They are
No,
not-
but it is apparent from this that
No.
whether now I will ask you, how did you serve him? Did he receive it? Did you receive it?
It was received, my lord. I'm not, it was received, my lord.
You received it.
Yes,
What
it was
happened after, my lord? It was received, my lord. I made a statement in paragraph 13, my lord. It was received. Instead of noting down the date, my lord, 17, it was noted on 18, my lord. On 18, the person went there, my lord. And then he was apprised notice, it was on 17. At paragraph 13, I have made a statement, my lord. Paragraph 13 of my petition, my lord.
No. If you have received it, nothing doing.
Then
File an appeal.
Only one last point, my lord. On 29th, when the hearing was done, my lord, I have submitted written submission, my lord. It was not considered. Page
Absolutely. If it is not considered, go and file an appeal. You get a chance out there.
one,
Nothing we-
opportunity, my lord.
Laho. The instant petition has been filed by the petitioner challenging the order dated 28/2/2024, whereby the adjudicating authority, that is the Assistant Commissioner of GST and Central Excise, has passed an order, thereby confirming the demand of the service tax and also directed payment of the interest and penalty, and also directed that interest as well as penalty be paid as adjudicated as adjudged therein. First, the sole ground on which the instant writ petition has been filed is that the petitioner was issued a show cause notice on
My lord, 22/10/21.
22/10/2021. Full stop. Thereupon, the petitioner submitted a reply on 27/3/2023. Full stop. It is also seen that the petitioner was heard on 29/3/2023. Full stop. In the meantime, the adjudicating authority changed and a new adjudicating authority was appointed, and the new incumbent adjudicating authority had duly issued notice to the petitioner. Full stop. There is no denial to the fact that the petitioner did not receive the said notice, wherein the date was fixed on 17/1/2024. Full stop. However, the petitioner having not appeared, the adjudicating authority disposed of the said proceedings by passing the impugned order. Full stop. In the opinion of this court, that this is not a case where there is any failure of natural justice, thereby to invoke the extraordinary jurisdiction of this court under Article 226 of the Constitution. Full stop. Taking into account that the petitioner has a remedy available under Section 86,
85.
80,
85 of the finance act. my lord.
85, has a remedy under the Central Goods and Service Tax
No,
Act
no, no.
2017,
Finance Act 1994.
Finance act.
Finance Act 1994.
under the Finance Act 1994, to prefer an appeal against the said order dated 28/2/2024. This court is not inclined to exercise the inclined to entertain the instant writ petition under Article 2 to 6 of the Constitution. Accordingly, this court disposes of the instant writ petition. Accordingly, this court not inclined to, sir. Be that as it may, taking into account that there is a limitation prescribed for filing the appeal within a particular period of time, that is 60 days from the date of the order, dated from the date of receipt of the order. Receipt of the order dated 28, impugned order dated 28/2/2024, which was duly received on
It is not written here, my lord. Sorry.
from the date of receipt of the impugned order, comma, this court, taking into account that this court, for the ends of justice, enlarges the said period of limitation, taking into account the pendency of the instant writ petition, and thereby permits the petitioner to file the appeal within 30 days from the date of the instant order. With the above, the instant petition stands dismissed.
Much obliged.
Mr. S.C. Kyle appears for the hearing. Yes, Mr. Kyle, whenever the matters are taken up of the GST, why you are nowhere there? And you send some junior of here who doesn't know head or tail about any matters.
I was online on IJOL bench.
Whatever may be.
I have,
One matter, there is one matter which is fixed on 7/8.
Yes, Lordship, I have already recorded his complaint.
Although I have struck out the personal appearance, but I said that if you don't produce the document on the next date, it shall be presumed that
In
not
this case,
known
Lordship,
such,
records were produced before the another court on last occasion. Lordship.
whatever may be.
I have record with me.
If you are too busy, ask somebody else who has some know about GST to appear. Or ask the GST council to
I'll take
appoint
care of
some
it.
more advocates. Next. Yes, what is your instructions?
No, Lordship, in fact, here they have filed an IA. In the morning, someone came to mention, but Lordship wanted to wait for the turn. And this is with regard to correction of page number 16. So this IA is not before Lordship. Maybe that might be the reason.
What
Not-
correction?
Replacement of page number 16.
Anyways, the question is page number
16.
16.
Yes.
Where is the council? The lady, there was a
Yes,
lady who
yes,
mentioned
morning.
the matter.
Morning, someone was here.
This is the application for that Silkaku thing. What are you doing? You are paying some 10 lakhs for RCC and some type 5 lakhs.
Yes.
What have you done here?
This has come for the first.
Who is the counsel who is appearing on behalf of the petitioner? Mr. T. Som, U. Hazarika, H. Das, none appears. None appears on behalf of the petitioner on call. So taking into account the above, the matter stands adjourned to be listed again on 2nd of August 2024. In the meantime, both the GMDA as well as the government advocate shall obtain instruction as to whether the petitioner's representation has been duly considered by the authorities for payment of compensation as sought for. Yes, what is this?
Here, my lord, pursuant to a sale notice published by the AITC for sale of the mortgage assets of erstwhile MS Sonar Kachar Publication Private Limited, the petitioner made an offer, my lord, and his offer was accepted. And he fulfilled all the criterias, my lord. And accordingly, possession was also handed over to him, my lord. Subsequently, but the registration was not done, my lord, because after the purchase, the petitioner constituted a,
Yes.
my lord.
But what happened was that though his bid was accepted, he made a partial payment and the remaining payment was made by some other persons. Thereafter, he made a request that the registration certificate and whatever registration process should be done in the name of a firm, which was not the bidder, madam. So that is why due to these difficulties, madam, we could not initiate the registration process. Now, my lord, they have filed this petition saying that, yes, the registration process, mutation and whatever can be done in his name. So,
In the
madam,
name
it
of
can
the
be done.
petitioner, yes, my
It
lord.
can be done now. There is no issue.
Do you have any instructions?
Instructions are also pending.
Listen, affidavit also. It starts from page number 30.
Page number,
30.
where is that statement?
Yes. Para number 11. 38, para number 11. It is stated that the delay in registration of the property is owing to the fact that the corporation has been receiving requests from the petitioner as well as from Dr. Ranbir Pal for registration of the property in the name of some third party. MSRD is a complete stranger to the transaction between the petitioner and the corporation. The deed of sale can be registered in favor of the petitioner as the payment was made on his behalf and possession of the
So
property.
you are agreeable? Therefore, the instant writ petition heard Ms. S.B. Chaudhary, the learned counsel, appearing on behalf of the petitioner, and Mr.
As thus.
S. Das appearing on behalf of the standing counsel of the AIDC.
Respondent number one, Lordship.
Who are you?
This, Industry and Commerce Department,
Your name?
N. Kalita.
Mr. N. Kolita appears on behalf of the respondent number one. Pusto. The issue involved in the instant writ petition is limited to the extent, is a limited one. The petitioner herein, in pursuance to
Sale notice.
in pursuance to a notice published for sale of the assets of the erstwhile MS Sonar Kachar Publication Private Limited, Silchar, had submitted his bid. His bid was duly accepted by the AIDC, being the highest bidder. Pursuant thereto, the sale certificate was issued, as well as the possession was handed over to the petitioner. The petitioner has approached this court on the ground that the respondent authorities are not executing the deed of sale in respect to the properties in favor of the petitioner. This court, by an order dated 3/6/2024, had issued notice and sought for instructions from the respondent AIDC as to why the deed of sale was not executed and registered in favor of the petitioner.
I got the representation.
In that regard, an affidavit has been filed by the respondent number 2, wherein it has been mentioned that the petitioner, though, was the highest bidder and had paid the amount, but the petitioner, along with one Dr. Ranbir Paul,
Page number 71, my lord.
wanted that the registration be done in favor of one MSRD Associates. And as MSRD Associates had nothing to do as regards the bid submitted or the sale certificate issued, the respondent corporation could not have executed and registered the deed and sale in favor of MSRD Associates. Mrs. X, this aspect of the matter can be seen from paragraph number 11 of the said affidavit filed by the respondent number 2. Mrs. S.B. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the petitioner is not adverse to the execution of the execution and registration of the deed of sale in respect to the property, in respect to the assets, but of the erstwhile MS Sonar Kachar Publication Private Limited, in respect to which the sale certificate was issued in the name of the petitioner. Taking into account the above aspect, this court is of the opinion that as the petitioner is not adverse to execution and registration of the deed of sale in the name of the petitioner, the respondent corporation should not have any fair objection, taking into account the stand taken in paragraph number 11 of the affidavit. Accordingly, the instant writ petition stands disposed of, thereby directing the respondent corporation, more particularly the respondent number 2, to execute and register the deed of sale in respect to the assets in respect to the property purchased, in respect to the property, in respect to the property which belong in respect to the property in respect to which the sale certificate was issued. Sale certificate dated date
Probably direct possession certificate was given.
Possession
in respect
certificate
to
dated 10
in respect to the property as described in the possession certificate dated
10/3/2018.
10/3/2018
18.
enclosed as Annexure 6C to the writ petition. The said exercise be carried out within
2 months. 2 months.
2 months from the date of the instant order.
Highly obliged.
Your Lordship, senior is on another court. Senior is on another court. Senior is on another court.
Who is
I
the
will pass.
senior?
Mustaq
What
Hussain.
do you want? The petitioner is aggrieved that in spite of the land being acquired belonging to the petitioner, the required compensation has not been released. Yes, what is this?
Well, Lordship, we have been asked to take instruction as regard the representation that he has filed before the Deputy Commissioner, but
Ah.
we have got the detailed instruction. So here, the enhanced rate has been calculated by the circle officer on the basis of the Water Resource Department Secretary's order. And that enhanced rate has been paid in total for all the total area of land, including 700 odd bighas of land, which includes the area of land which the petitioners claims. In total, enhanced amount has already been paid. So there is a sanction order as regard the total payment.
Sanction whether the petitioner have received the money.
It is
No,
said received from the Deputy Secretary amount of rupees which has been kept at the Axis Bank, Mongolway branch. So this is the order. This is the sanction order.
How much the petitioner is entitled to? 2,32,000, 2 crore 32 lakhs.
Enhance. That is his claim. That is his claim. But from the calculation that has been made,
Did you receive any money?
No, my,
finance mom,
no,
Award passed.
nothing, my lord, not only NS, my lord.
this sanction has been given way back in 7th of December 2023. Hello,
Award passed.
yes. Yes.
Has the award been passed or not? This acquisition is done under what?
For my lord, construction of my lord river bank.
What is this? This is another petition.
Yes, there. Asiruddin Ahmed, he filed another writ petition. So there he claimed an enhanced amount
Who
along.
is Asiruddin Ahmed?
That is, he is one of the claimant with regard to the total area of land which has been acquired. So that what I can make out.
Where is your dark numbers?
Dark number.
Land which have been acquired? So the land as per the schedule measuring an area of 79 bighas, 3 kathas, 8 lechas in village so and so shall be acquired for construction of the marginal embankment along with both rivers of river Ghogra. Who are you? Where are you? Where is your name?
My lord. At page, my lord,
Who are the petitioner's name?
19, my lord.
21.
Page 19, my lord.
Wait. Syed Isfaq.
Syed
Hussain.
Ishfaq.
One person.
Yes, my lord.
Only one person. Okay, here, 1890, 18 and 21, name of the Pattadas. Okay. Then- So your name features in the section 6 notification. This
Yes,
section
sir.
6. Done under section 6 or what? Shall be acquired for construction.
Election 6.
Where is your patta number? Your patta number is here. Where is your land?
Page 21, my lord.
His patta number is 7 and 23.
This was issued when? 2003. And they issued a section 4 notification. This is done under section 4, Land Acquisition Act, 1898,
64.
1864, 1894.
1964.
No, kindly see page 24.
No.
Page 18 it says 1964.
Huh?
Page 18 of the repetition.
But that is okay. This is done in 2003. And what is this? Annexure 2. Possession was taken in 2008.
Gazette notification for 2014 of publication.
Huh?
Really got 3 katha.
My lord, yes, my lord. So at page 27, my lord, last page, possession was taken, but physical possession was taken, my lord, at the immediately notification because the
In 2008.
2003, my lord. Because, my lord, it was the river bank site, my lord. Embankment.
Page 27 possession was taken over in 2008.
So again, you did action under section 9. Section 9 is urgency.
Hmm.
This was done in 2014.
14.
Huh? And there is an application for enhancement in 2014. And you have not taken into action anything. Why have you referred this to the reference court?
That is not reflected.
Huh? Who is going to pay for the interest? Ask the deputy commissioner. Who is the deputy commissioner Dorong at that point of time in 2014? Is he going to pay from his own pocket the interest? Or is it going from the public funds? There's an application for reference Why haven't you taken any action?
Let me have my, put it on record by way of my affidavit. Just for the first time.
Affidavit along with the name of the deputy commissioner then,
Yes.
who have received this document and have not made the reference. And if he is still in service, he has to pay from the entire amounts will be deducted from his salary. Goodness. Are these people hand in glove with the people persons or what is, I don't understand. What stops them from making the reference?
2014. Hmm?
Is this Asiruddin person that 84-year-old person?
Yes, my lord.
Huh? Matter done by R.C. Das. So irrigation. Water resource.
Another 80.
Well, the amount seems to be very similar, 84 lakhs.
84 lakh 40,000.
Because I remember that 84 lakhs was the amount.
The case number is 4942.
That person was 84 years. Issue notice making it returnable, short notice, issue notice making it returnable on 19th of August 2024. Mr. Ebocharji appears on behalf of the respondent number 1 and 2. Mr. S. Borwa appears for respondent number 3. None appears on behalf of the Water Resource Department where the matter has been called. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that there is a standing counsel of the Water Resource Department. You have not given copy to the Water Resource. Mr. Counsel, you have not served copy to the Water Resource Department.
My lord, in last occasion, my lord,
Where was the last occasion? No, we need to file.
19/6, most probably we served, my lord.
Huh?
19/6, my lord, on by order dated 19/6 notice was served.
This concern. Ajib Borpujari, yes, sir. Yes, why haven't you given a copy to the Water Resource?
Resource Department, my lord, copy is subsequently given, my lord, on my lord.
No,
My lord,
no.
On 25/6, my lord,
None appears on behalf of the Water Resource Department of the Government of Assam. Full stop. The Learned Counsel, it is seen from the records that at the time of filing of the instant writ petition, the service of notice have not been effected upon the respondent number 4. C. Sharma. Mr. C. Sharma, who is present in the court, is the standing counsel of the Water Resource Department and submits. Then don't make a submission. Go. You have no business out there. Where you coming? So what do I do? Not necessary. Not necessary. Hey, Bukatok. Don't kindly disturb the court proceeding unnecessarily. If you are appearing as a standing counsel, say that. Issue notice making it returnable on 12th of August 2024. Mr. A. Bhattacharjee appears on behalf of the respondent number 1 and 2. Mr. S. Borua appears on behalf of the respondent number 3. None appears on behalf of the Water Resource Department when called. It is seen that at the time of filing of the instant writ petition, the petitioner had not effected a service of a copy of the writ petition upon the standing counsel of the Water Resource Department. And it is for that reason neither the name of the standing counsel of the Water Resource Department has been shown, nor anybody is present. Under such circumstances, the petitioner is directed to serve 2 copies of the writ petition upon the standing counsel of the Water Resource Department during the course of the day. As regards the respondent number 1, 2, and 3, as the counsels are duly represented, extra copies of the writ petition also be served during the course of the day. The case of the petitioner herein is that the land of the petitioner it is the case of the petitioner that the respondent authorities had taken over the possession of 3 bighas, 3 kathas, 1.5 lechas of land belonging to the petitioners in connection with LA case number 6/2001-02. However, the petitioner have not received any compensation in respect to the said amount. On 11/1/2012, that is almost after a decade, the petitioner was served with a notice intimating that the petitioner would be entitled to compensation of an amount of rupees 1,55,022 for the lands which was taken, the possession of which was taken over. This aspect was intimated to the petitioner on 11/2/2012. Thereupon also, the petitioner did not receive a single penny. As such, the petitioner represented before the Minister of the Water Resource Department. Thereupon, in respect to the same land, a notification was issued under Section 9(1) of the Assam Land Acquisition and Requisition Act. Is it under 9(1) or what? 9-1 is under, where is the document? Under section 9 of the Assam Land Acquisition and Requisition Act 1964. This notification was issued on 18th of March 2014. The petitioner immediately had submitted an application for enhancement of the compensation in terms with the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. It is the specific case of the petitioner that the proceedings may have been initiated prior to the Act of 2013 had come into force. But in view of Section 24, the petitioner is entitled to the compensation as in terms with the Act of 2013. It is seen that the said representative application was filed as far back as on 6th of March 2014. And it is not known from the instruction which have been placed by Mr. S. Borua during the course of the hearing today as to whether any reference proceedings have been initiated on the basis thereof. Under such circumstances, this court directs the Revenue Department as well as the Deputy Commissioner, which district? District Commissioner, Dorong District, to file their respective affidavits thereby stating the status of the acquisition proceedings in respect to the land belonging to the petitioner, the details of which have been given in paragraph number 2 of the writ petition. And as to whether the application seeking enhancement in terms of the Act of 2013 has been referred to the appropriate court for deciding as regards the appropriate compensation. The said affidavits be filed without fail by 9th of August 2024. Give a copy during the course of the day. Don't file it in this manner.
Lordship, in this matter, we will file our affidavit by tomorrow, Lordship.
Who are you?
Lordship, I am appearing on behalf of respondent number 1 and 4. 1 and 4, Lordship. Water resource.
You are not Water Resource Standing Council. No, don't appear. No. How can anybody else appear? Yes, tell me, madam, what is your case?
May I please lordship? In this case, my lord, the petitioner's lands acquired by the respondent authority without any legal procedure adopted, my lord. Neither they paid any compensation amount, neither any opposing to file any objection, my lord. They illegally
Where is the acquisition proceedings?
my lord, they not follow the
No acquisition proceedings. And your land has been taken over. When?
in the year 2008,
2000?
2008, my lord.
8. By whom?
The deputy commissioner. of Finance.
Yes, Deputy Commissioner. Why have you taken over the land? Hemaji?
And without the file, in fact, we are not reflected in the constitution.
Earlier, somebody appeared. Miss S. Bolwa appeared, the learned government advocate for respondent number 3 and 5. R.N. Bolwa appeared for the Finance Department. Revenue Department P.R. Mohanto. One Miss A. Lodha appeared for respondent number 1 and 4.
Maybe the cause list left out the government. We have not been reflected in the cause list. So let it be on another day.
Tomorrow? List the matter on Friday. Day 2. promotion showing the name of Mr. S. Burwa. You appeared on the last occasion for 3 and 5.
Maybe, but the record is not before me. The file is not before.
Showing, showing the name of the government advocate, G.A. Sam.
Okay, most.
Puस्तक.
Yes, no problem.
Mr. S. Burwa submits that he could not obtain the instructions, taking into account that his name has not been reflected in the cause list. Absolutely. List the matter on 26/7/2024 at the motion, showing the name of Mr. S. Burwa for GSM. Mr. S. Burwa is directed to obtain instructions from the District Commissioner Dhemaji as to whether any acquisition proceedings have been initiated for taking over the land of the petitioner on the next date. Here's what it is. You have not received the compensation. Yes, NHI, you have given the compensation to the Deputy Commissioner.
What happened in this case, the project is under NHIDCL. Not
NHIDCL.
So they have not made party the NHIDCL in this case, Lordship. So then we can give like.
How do we know that the project is under the NHIDCL?
Taken instruction from the department, Lordship.
Your department may say so. When the question of payment comes, it may say so.
My lord, page number 22.
It's a
my lord.
competent authority.
Page
Lordship.
20?
My lord.
Yes.
My lord, already specifically. Central government hereby authorize the officer mentioned in column number 2. Column number 2 is the additional deputy commissioner.
Additional.
Yes. Mr. S. Burwa?
Yeah.
We have sent a communication, but instructions are waited.
Huh?
We
What
have,
instructions are waited? 1 month it has gone. You have taken somebody's land and not making the payment? Return the land. You return the land. You can't take over the land in this manner. You were issued notice. You were issued. Your instructions were sought for on 19/6. 1 month has passed by. You see the plight of a person whose land has
let
been
it be-
taken away
let it
and
be,
not by not making a compensation, not paying payment of compensation.
let it be next week, I will ensure. I will ensure by.
Friday, no next week business. Friday. If you have not paid the compensation, return the land. Which is the land, Mr. Council? 3 bighas in Dag number 121 of Patta number Iman, village Okazan Miri of Sisirian in district of Dhemaji.
Out of 3 bighas, my lord, 9.10 lesser, my lord, has been acquired.
Only 9.1.
My lord, page number 35, my lord.
Return that land.
My lord. This is the total plot, my lord.
Page 30.
35, my lord. 35.
Which land?
Plot area, my lord. 2 bigha, 2 katha, 13. Already he has, my lord.
Who
Road
has?
area, my lord, 9.10, my lord.
Which land? On the side.
My lord. Right, my lord. Reflected, my lord.
Is it shown anywhere in the notices?
No, my lord. My lord, my name has not been enlisted. Therefore, already I have paid before the authority, my lord, page number 33 with the representation, my lord.
3.
Page number 33, my lord.
Your name has not been shown.
Enlisted, my lord, in the compensation column. Therefore, this is the application, my lord. 34 is the pair, my lord.
Now, in this notification, which has been issued under section 3A, your land is there?
No, my lord. No, therefore this is a pair, my lord.
What is your prayer?
My lord, pair 34, my lord, pair.
So this is, they have not taken it has nothing to do with NHI.
My lord.
It is to do with them. The deputy commissioner has forcefully taken over the possession. And how much? Where have you mentioned 9 letters?
My lord, this is the survey report, my lord, page number 35, my lord.
Page number?
35, my lord.
Whose report?
35 road area, my lord.
Who has given this report?
My lord, this is a private surveyor, my lord.
No. Your land has been taken away. Mr. Counsel, why you have been not specific in your prayer? Your specific case is 9.10 letters of land has been taken away from your land.
My lord. This is
So, Andasa, why you are not clear in your prayer? What is your prayer?
Notification of accusation.
My lord, commanding the respondent to compensate the petitioner.
For
In
which?
respect of the claim seeking compensation for acquiring the merely land. of
For
the-
acquiring means the entire. Do you want the entire 3 acres of land to be taken?
Page number.
First
11,
of
my lord.
all, they have to acquire your land.
My lord, page number 11.
Is it your case that the land has been acquired?
And not entire 9.1 letter.
Has it been acquired or possession taken?
All possession has been taken.
Has it been acquired?
No, my lord, therefore I paid to before the
Therefore,
authority to enlisted my
your
lord.
prayer should be specific
My lord.
that in respect of 9.10 letters of land which was with you, which have been taken over, either you acquire or pay compensation for that. Why it is not that? Your prayer is not clear on that.
My lord, page number, no, there is no mention in PR, but in page number 11.
So we are going to search everywhere. Hello, we should. I'm not properly satisfied with your case. Okay, we issue sometime in the month of October. Issue notice making it returnable on 9th of September 2024. Mr. NHAI, who is appearing? You are appearing. Okay. Ms. So-and-so appears on behalf of respondent number 1 and 2. Mr. A. Bhattacharjee appears on behalf of respondent number 3 and 5. Mr. S. Borua appears on behalf of the respondent number 4 and 6. And Mr. B. Gogoi appears on behalf of the respondent number 7. As the respondents are duly represented, extra copies of the writ petition be served upon them within 2 days. First, the respondents shall shall bring on record their stand by filing the affidavits on or before the next stage.
Okay.
Whether GST is leviable on advocate's income. The notice was issued in March 22. That your lordship will find it at page 13. Reply was given, but it seems another demand notice has been given in June 24.
GST has to be imposed on
Advocate's income.
Service tax.
Service tax.
Advocates are exempted.
Advocate's income.
service tax on what?
On advocates, income earned by the advocates,
Advocate.
which is in negative list. But let's see what happened, before when the executing authority or passed the order, they were not aware that the petitioner is an advocate or not.
Huh?
Yes. They were not aware whether the petitioner was advocate or not. Notice was issued on the basis of information received from the income tax department. And Lordship, my instruction that advocates are exempted from the service tax.
So we quashed the notice.
Because if final order was passed.
Where?
Lordship, time please. Was passed. Page 13, Lordship.
Page
Page 13 on 30 March 2022.
13,
3032, page 13, Lordship.
page 31. In exercise of the powers of so and so, so and so, so. What is this?
No, Lordship, page 13.
Respect of services or agreed
One
to be provided by individual advocates or the service. The extent of service tax payable thereon by the person who provide the service and the person who received the service for the tax shall be specified. Percentage of service payable by the person providing service nil. Percentage of service tax payable by the person receiving the service 100%. Okay, then
See, that was the difficulty before the authority and this order was passed. And in fact, Lordship, advocates fall under the negative list. So
no, it is the payment is to be made by that person who avails the service.
that is reversal mechanism in GST regime. Lordship. This matter was relating to Finance Act 1994.
But this is for the service tax.
Yes, service.
Now, what has happened for the GST?
Lordship, GST, individual advocates are not liable to pay.
No, what is being challenged here, Mr. Counsel?
This
Page 13.
matter of recovery at page 25.
Tell me that. You are confusing this court people. Monto Kumar Sharma, please refer to the order dated. The service tax amounting to Iman along with requested to pay the arrear amount within 15 days. So this has been challenged.
Yes.
So we set aside this.
Initially, notice was issued in the March 22, page 13.
Final order. The final order.
Yes.
This is the notice demanding 1,34,000 for the year 2014-15.
Uh,
Lordship will find it at page 14.
then
And
you
my lord,
wrote
he
a
has
letter.
given a representation, page 17.
Then
Representation they did not consider. Similar representation considered in respect of another advocate. Your Lordship will find it at page 19.
Uh.
And that was withdrawn.
with
Page-
you.
My lord, yes.
Yeah.
Yes.
Then
Page 23, my lord.
Mr. Kyle must have been they had must be-
Many advocates filed writ petition that we have disposed of. We do, but see what happened at the notice was
So
challenged.
there
in
your
the- all
Lordship
these
will find
writ
at page 23. So similar representation, the petitioner also filed. And again, my lord, they have passed an order for recovery of service tax. I think they have not taken into consideration the representation filed by the petitioner. And also the fact that he is an advocate. Karnataka High Court, my lord, batch of writ petitions have been disposed of.
no, whatever may be, in view of this notification,
Paragraph,
this is of the 20th of June 2012. How can there be any demand being made?
What happened before the authority, when the data came from the income tax department, it was not indicated whether is an advocate or is exempted. That matter was not placed before the authority.
So what are you going to do?
Lordship may pass necessary order directing the authority to consider or may Lordship cause the demand notice also.
Huh?
First,
Why should I ask somebody to do something? I can quash it,
Yes,
I will
Lordship.
quash it.
Lordship may pass necessary order. possibly.
Unnecessarily keeping these matters pending doesn't make any sense.
This is a new matter, Lordship. Lordship may cause the order because.
Because here it from this notification of 30/2012,
Yes, Lord.
it is seen that the percentage of service tax payable by the advocate is nil.
Yes, Lord.
but the person who is receiving the service has to pay 100%.
Yes, Lord.
So as per that, the amount could not have been imposed upon the petitioner,
Yes, Lord. Correct.
but could have been imposed upon the person who paid the. I think that is the fair thing.
Yes, Lord. So my first decision, we are.
Karnataka High Court has, my lord, recently disposed of batches of petition. That will not
But
be-
Mr. Kayal, should I take up this matter at this? Because I also had a same problem. Should I? But I have been exempted, like Mr. BD. Yeah. As a lawyer, I have been exempted.
Officer also, he said that in earlier cases, demand notice was put under challenge. Here final order was passed.
Understood. But then also, one has to say, no, I'm not on that. The question is, should I
No.
take up the matter?
There is no bar, it has to be.
I was also a beneficiary like you.
Other,
Like Mr. BD does, I was also a
yes,
beneficiary.
Mr. Soumitra Soikia, my lord, he also had similar type of problem like us.
No, no,
He has taken over.
no, notice.
No, he didn't have. I have. So let the matter be listed before any other bench. But I had got a similar like order like you.
Therefore, my lord, on the basis of the same order, your lordship may dispose. of
Understood, but
it was
it would not, because it would not be proper on my part. List the matter before any other bench.
Item number 10, this may be also be disposed of. Lordship may come to case 436, 466.
What is this matter?
Regarding the interest on refund order of central delay refund.
Huh?
Delay refund of central excise. Refund we have already entitled, we have already received back the refund order, the refund of central excise as per notification. But there is a delay on the part.
Of?
Dispersing the principal amount. Refund amount, there was a delay in dispersing the amount. As per the judgment of this Honorable High Court, that we are entitled to pay interest on that amount. But the matter is pending before the Honorable Supreme Court. Lordship may come to page 465. Really everything will be clear. Paragraph 16. Page
We are
4,
claiming interest on the
465.
basis of 11 BP of central excise. There we are entitled to get.
Paragraph 16.
So, you want, why are you not giving the undertaking?
No, that's what I am telling you, my lord. Now they have raised this question undertaking. Apart from
No,
that,
no. I know this case because earlier when I was taking up, wait, there is a direction passed by the division, single bench, it was directed, then the matter went to the division bench. The division bench said that you are entitled to the interest.
yes,
The matter, the SLP is pending. However, there was a direction being passed by the division bench to the effect that if you want the money, then in that regard, you have to give an undertaking that in the circumstance here. And you have not given the undertaking and it's
that by giving undertaking. In my case also I was as well. But one case is that they have raised one technical problem. Law point is involved. People also go through a 465 page. They have raised that this is not a refund. They are telling this is not a refund, which is already decided by this division bench judgment. I will give it as this.
No, we are not concerned. The question is, you want the money?
Yes, my lord, if you also direct, I will give an answer.
I know, you go and submit your undertaking, matter ends.
But they, after giving undertaking also, they will raise same problem. Yes,
No, Because once the matter is finally decided by the Supreme Court, nothing remains.
Yes.
Because that issue was the issue which they had taken. They had taken that issue in that case of the Dharampal, na? They had taken that issue out there, which was negative by the division bench.
Yes.
And therefore, the matter went to the Supreme Court.
Yes, please tell them.
And the Supreme Court had though have issued a notice, but did not say there is no stay.
Yes.
And as such, this is the being direction given. Then go.
The simple thing, Lordship, they give the undertaking, it will be paid to the.
We record that Mr. S.C. Kyle submits that if the undertaking is given by the petitioner, they will make the refund.
Yes, yes.
This
That order.
order says like this. Lordship.
Anyway,
Yes, Lord.
we close it.
Submission be recorded. Otherwise.
We'll close it in that.
Yes, yes, yes.
The heard Mr. S. Mitra, the learned counsel appearing on behalf of the petitioner, boiling so much of environmental excess. It's the petitioners, Mr. S.C. Kyle appears on behalf of the
2 to 5 Lords.
respond number 2 to 5.
I am one, my lord, senior nominee.
So and so appears on behalf of the respondent number 1. The petitioner herein has assailed the order dated 25/5/2024 passed by the Assistant Commissioner, Central GST Division, Dibrugarh, whereby the interest claim of rupees 4,48,92,856 have been rejected on the delayed refund of excise duty. It is seen from the records that it is seen that that similar issue as regards the entitlement of interest in terms with section 11B, single B,
Double B, BB,
11 double B
double B.
of the Central Excise Act 1944 have been already decided by the division bench of this court in the case of
Amalgamated plantation, madam.
where
Now, the judgment I put it, if you want, I can give you the copy of judgment also.
in the
And I've
case
put
of
it in my petition also. Okay, the plantation, page number.
The number is there now, name is not read appeal 102 of 2020.
you have enclosed so many things unnecessarily except this.
Page 40, you have to go to page 44.
Page
44.
44.
Yes, madam, in my petition.
Where?
Page 44. Delivered by division bench on in Union of India and others versus Amalgamated Plantation Private Limited. 2016 SCC online, Guwahati 754.
And yeah.
That's all.
This is a review order.
Review order.
Where is the main order?
I'm just giving you my lord. Page 40.
Okay. It is seen that the issue involved in the instant proceedings have already been dealt with by the division bench of this court. In the case of Amalgamated Plantations Limited versus Union of India, reported in 2012 SCC Online GAU 549, wherein it has been held that Section 11B of the Central Excise Act 1944 does not exclude claim of refund made in terms with the notification dated 8/7/1999. It was further held that the petitioner would therefore be entitled to interest under Section 11BB of the Central Excise Act 1944 on the excise duty refunded to them. The jurisdictional excise officer in the said case was directed to determine the interest amount payable to the petitioners therein for the relevant periods and be paid to the petitioners therein within 3 months from the date of the said order. It is seen that being aggrieved, the Union of India have a union or the Central Excise Department. Who approached? Where is that order of the Supreme Court?
Order.
Where is the order of the Supreme Court?
Order is order of the Central Excise.
Yes.
Huh? Dharampur suitable order I am not.
Where is the Supreme Court order?
I have not annexed court order. What is that, sir?
It is seen that pursuant thereto, who challenged it?
I can give you one SFA number I can give you. Page 51.
Mr. Mitra, you should be knowing this. You have just copied and pasted some petitions from somewhere. Don't know anything. What no?
Drafted by me, not pasted.
It is seen that thereupon a review was sought to the judgment passed by the division bench in the case of Amalgamated Plantations Private Limited, Supra, which was, however, dismissed by the division bench of this court. Full stop. Thereupon, an SLP was prepared by the who prepared the SLP? By the Union of India against the judgment passed in Amalgamated Plantations Limited, Supra to bracket, which was registered and numbered as SLP number 016322/18. The said SLP, leave granted,
Not, leave not granted. Not yet.
you don't know.
Was dismissed and the law point was kept open. Also. The SLP was dismissed on ground of delay. However, law point was kept open to be executed in some.
SLP was dismissed.
Yes, sir.
No, this is not the Jharpal. That is not the Jharpal.
No, earlier, I guess amalgamated.
Then
Lordship, in further proceeding, which same order was passed, then that has been pending before the Supreme Court in case of Dharampa Satyaka.
MK Jokai,
Jokai order is challenge that order
That is the writ appeal 102 of 2022, where we referred appeal against the passed by the order passed by the CSEC. We are directed to pay the interest.
Mr. I won't pass an order today. You get the order on Monday, on Friday. Get the proper details. What has happened? You can't just come up with a petition like this without knowing where. Which order has been passed where? Because I remember, you see, there was a pass order initially passed.
Yes.
Then the matter went to the Supreme Court. That was withdrawn,
Yes, Lordship.
keeping the point open.
Yes.
Then similar order was sought from in the case of MK Jokai.
Yes, Lordship.
That matter has gone to Supreme Court.
That was also dismissed. And Lordship, thereafter, in case of Dharampal Satyapal, this honorable court passed similar order directing the department to pay interest. Then ultimately the department went to Supreme Court, that SLP is still pending.
What is that order passed in the SLP?
SLP Lordship notice was issued, but no stay has been taken.
Produce those.
Yeah.
List the matter again on Friday.
Much different.
Properly prepared, Mr. Mitra.
Not that.
You are not prepared.
No, I'm not prepared. That.
I can do one thing. I can issue notice making it returnable in the month of October. You want that? Then why you are not coming up with a proper thing properly? You don't know head on tail about anything. You are quoting orders, some orders from this way, that way. Where are orders? Bring the judgments which have been there. Why you are not bringing it? You don't know which SLP has gone where. Here you are making a reference to some SLP from where. I think the order passed by the officer is more clear than what is stated in your petition. Come prepared. Don't come up in a matter. Your petition is 600 pages and you don't know. That will be on Friday. Come up prepared.
Was deducted from my account over a digital fraud. Approached them, with my claim, I approached the Ombudsman of Reserve Bank of India also. There also, they said that there was a deficiency.
You inform immediately.
Yes, it was within time. On 11th of January took place. I approached them on 12th. On 11th itself, I filed an FIR also. From there onwards, till the month of October, I pursued it. And in the month of October.
Why it has been rejected?
The SBI rejection is a one-liner, my lord. Whereas if your lordship would kindly come to the rejection of the Ombudsman of RBI, your lordship would find it at page 32, annexure 8. Complaint regarding unauthorized EOS transaction of 75,000 on 11/1/22 was taken up with the bank. And the bank has submitted that the transaction was executed through two-factor authorization. You have informed that your ATM card was swapped.
Why haven't you enclosed the RBI circular? That is your main case.
Also, an advocate of this court, he as a petitioner in person, he approached this court by the name of Pallab Bhumik. So his case was allowed. That was a transaction.
That matter is pending before the division bench.
Yes, on 5th of October last year, it was reserved. So after that, I don't think the judgment has been passed.
That is different, but RBI, there is a circular of 6765. The date of the circular. Who is RBI? SBI. You are SBI?
I am appearing for that.
RBI, there is a RBI circular, no?
There is a circular, it is indicated in the order, at page 32. Annexure 8. In fact, my lord, page 33, my lord. Paragraph number 3. Accordingly, the complaint has been closed under clause 16(2)(a) of the Reserve Bank Integrated Ombudsman Scheme 2021, which reads as under. Complaint is rejected under clause 16(2)(a) of the Reserve Bank Integrated Ombudsman Scheme 2021. In the opinion of the Ombudsman, there is no deficiency in service. Now, my lord, keeping PIN code of the ATM is the responsibility of the, my lord, the customer, not with the bank.
The ATM card, what happened to your ATM card?
I went into the ATM. I withdrew an amount of 9,000 rupees. The moment I came out, I had a card of someone else.
How?
That is my case, and I immediately preferred an FIR also. I informed the bank also that once some Phanindra Boiso, his card came with me. Immediately an amount of 75,000 was deducted.
No,
Now-
you put the ATM card inside the ATM
I withdrew.
and you got out another card.
Yes, that is what happened.
How is it possible?
Well, no investigation
that
was
is-
carried out by the police.
That
I
is
have added
what
them as
Millard
parties.
surprising. That is what Millard surprising. When he was taking up the Millard the card, he did not see Millard as to whether the card is belongs to him or someone else. Thereafter Millard how
Few
how
questions
this Millard
also remain unanswered, my lord.
Now,
The
Millard-
amount is of 75,000. ATM doesn't allow in 24 hours a withdrawal of more than 40,000 rupees. Also, my lord, an ATM in one time doesn't allow a withdrawal of more than 10,000 rupees. I can withdraw 10,000 rupees 4 times. I can go up to 40,000, but that is the limit for 24 hours.
No, this transaction seems to have been made not by
In
way
the
of,
same ATM machine, my lord.
it
The
can't be
9,000
an ATM.
It says ATM cash. 6576 Hengrabari.
No, no, it is not ATM cash.
The
No,
second,
ATM cash is 9,000, which you have taken out. But the second one does not appear to be an
So when-
ATM.
when someone else's card came with me, I also received the phone call from the authorities. They said that there's a transaction of 75,000 rupees. I said it is unauthorized. I didn't do it. So that is how I came to know. Immediately, I preferred an FIR on the same day itself. On the very next day morning, I went to the bank official. Blanket
Anyway,
rejection.
let
instead
them
of
file an
blanks.
affidavit.
Matter.
Issue notice returnable by. Why do you need the ombudsman? Ombudsman necessary?
Their rejection. It has to go.
Notice making it returnable by 23rd of August 2024. Last, isn't it? 23rd? No. 26 Mondoni. Huh? Mondo. By 28th of August 2024. Mr. appears on behalf of the respondent number 2.
Shan Millard.
N. Goswami appears on behalf of the respondent number 3. As the respondent number 2 and 3 are duly represented, copies of the petition be them during the course of the. As regards the respondent number 1, the petitioner is directed to take steps by way of by way of registered as well as usual within 3 days. The respondents shall on or before the returnable date file their affidavit bringing on record their stand. But I think you will need to bring on record that circular. RBI.
I'll sign an action. No pleasure.
Well,
I lodged an FIR 27th of May before the Mandatory police station. That FIR was not registered, nor even any investigation was done, my lord.
They have not registered the FIR?
No, my lord. Then, my lord, I approached the Suvarnabhumi police, my lord, that annexed 2, my lord. Your lordship will find page number 14.
If they have not registered the FIR, why you are not approaching under 156(3)? And or what will be the now the provision, the relevant provision as per the Sanhita? Where is that book?
Earlier also, my lord, dispute and similar cases, my lord, pass the similar direction, my lord.
And the Arvekhan is also.
Earlier, my lord, it was 156.3, my lord. CRPC, as per CRPC, it was 156.3, my lord. And
So it will be 176, 75.3. So this happened after 17.
Happened at 27.5.
Or then it will be under 156.3. File an application under 156.3. Why should do this court entertain this 226? There are many judgments.
my lord, still this court, my lord, can pass a direction, my lord.
Huh?
Only to see that the FIR is registered. Otherwise, my lord, I approach this one of police also. But the police, they are not actually exercising their statutory power, my lord. That is the, my lord, that is my grievance, my lord. Otherwise, my lord, only, my lord, previously also this court issued similar direction in other cases also. My lord. I have one of the judgment of this court, my lord, previous judgment.
Sorry. Go there. File an application.
It's a very serious offenses, otherwise very
So what?
serious. Why-
Whether an FIR has been registered or not, that is the authorities are to look into it. You don't exercise 226 for that.
Yes.
When the law has been very clear, many judgments, not 1, 2, 3, 4 judgments.
Let them have instruction from the police station whether the police have registered the FIR, not registered the FIR.
So, nothing doing. Therefore, the petitioner heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. N. Goswami appears on behalf of the respondent. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities, more particularly the officer in charge of the Mankasa police station, as well as the superintendent of police, South Salmara, Mankasar Hatsingmara, in not registering the first information report dated 27/5/2024, wherein serious allegations have been leveled against the accused persons. This court, taking into account the settled position of law in the case of State of UP versus Sakira Basu,
State of AP. State of AP.
State of
AP.
UP versus Sakira Basu, reported in 2004
Sakiri Basu was the state of AP.
versus
State of AP.
reported in 2004
2008, 2 SEC 409.
409, is of the opinion that the petitioner would be well advised to approach the jurisdictional magistrate under section 156(3) of the Code of Criminal Procedure 1973, taking into account that the incident happened prior to 1/7/2024. Under such circumstances, this court, while not entertaining the instant writ petition, grants the leave to the petitioner to approach the appropriate forum.
13.
With his lordship. The petitioners are, my lord,
Huh?
petitioners, they are occupying land, government, government land, my lord, from
Who is occupying government land?
petitioners, my lord,
Why?
since 1954, my lord.
Then
In the meantime, the circle officer may issue, my lord, the eviction notice. Then the petitioner reports this one about court, file a writ petition. And they said the petition was disposed of directing the petitioner, my lord, to
which notice?
my lord, order page 50, my lord.
Page?
Page 50, the order passed by the Honorable Court. My lord. Page 57 is the, my lord, relevant portion of the order.
Then what happened?
Then, my lord, the petitioners submitted their individual representation before the authority, my lord, but that was not disposed of. So, my lord, one contempt petition was filed, my lord, that was pending. The stage of issuance of notice, my lord. In the meantime, my lord, the page 72 and 73, my lord. The respondent number 7 and 8 may issue a notice to the letter to the, my lord, District Commissioner Dorong, my lord, page 73. For allotment of the land under possession of the petitioner.
Then
This is my case, man. Page 73, man.
how do you know that this land belongs to you?
My lord, the description given in the, my lord, dark number,
Where is the dark number?
the page 73, my lord. Please refer to office of the so and so, wherein.
Dark number 833.
Yes, my lord.
And what is the area of dark number 833?
6 figure,
Only.
my lord.
And you are occupying it.
Right.
And you
Paragraph
submitted a
5.
representation, the representation is pending.
Yes, my lord. Pending, my lord,
Representation for what?
for settlement of that land, my lord.
How can, did you apply for a settlement?
My lord. My lord, in
How?
terms of the order passed by this honorable.
No, no, you have to apply for settlement in accordance with law. Settlement has to be by filing an application in either in the Vasundhara 2 portal or by way of filing application in form 125 and 126. Have you done that? No. Then why should we stay? You want for settlement, you have to file an application for settlement. You are ventilating your grievance that you should not be thrown out.
Yes.
That's all. So, but what is your right if you are not asking for settlement?
As per Assam land policy, my lord, clause 1410, my lord, says, my lord.
Huh?
Assam land policy in 2019, my lord.
What does it say?
1410, my lord. The land originally falling under rural area, but subsequently included in the revenue.
That is subject to you filing an application.
My lord.
Have you filed an application?
My lord, my lord, they belong to, my lord, the SC community, my lord. And
ST community, they are exempted.
the special provision is there for them.
Understood. But are they exempted from filing application?
No, my
Then
lord.
why you are not filing application?
I'm filing representation as per.
Representation
Direction of-
cannot, by way of representation, you cannot get a settlement. The settlement has to proceed in a particular manner. If you have not applied for settlement, where is the question of you getting anything? What do you say, Mr.
Otherwise, in page 57, there is status quo order is still in force. Yes.
Huh?
That is earlier earlier order. Order start from.
Until such time the above exercise is carried out and status quo as on regard the possession of the over the land in question shall be maintained. So it is already maintained if it has not been disposed of. Why do you need a stay?
Contempt proceeding of pending, my lord.
Contempt, why have you filed a contempt?
Since, my lord, the representations were not disposed of, my lord. That's right.
The moment they
Time-
the
time-
moment they dispose of, you will be thrown out. Isn't it? You are not asking for settlement, then why will they consider your representation?
My lord, I am complying with your order passed by this honorable court.
No, you have complied with by filing a representation very well. They have not disposed of very well. Until then, you are enjoying the status quo very well. You enjoy it, but why are you filing a contempt? The moment you are filing, are you not putting the fire out there and say that okay, now dispose it of as early as possible and throw me out? The status quo goes for a 6. Yeah, nothing is there. What is there? You have not filed any application. What right do you have? And why are you challenging this?
My lord, they are processing, my lord, the allotment of land to the, my lord, ESI. Yes.
Issue notice making it returnable by 16th of August 2024. Union of India, none appears. Have you served copy upon Union of India? Their name has been shown in the cause list.
Don't mind.
Huh?
Don't mind.
None appears on behalf of the Union of India when the matter has been taken up and service of notice have been duly effected. Mr. A. Bhattacharjee appears on behalf of the respondent number 1.
I do. I've got two.
Or respondent number 2. Mr. N. Goswami appears for the respondent number 3, 4, 5, and 6. Before directs taking into account that the respondent number 2 to 6 are duly represented by their respective counsels, the extra copies of the writ petition be served upon them by tomorrow. As regards the respondent number 1, the petitioner is directed to serve a copy, an extra copy of the writ petition upon the learned CG, the learned Deputy Solicitor General of India. As regards the respondent number 7 and 8, the petitioner is directed to take steps by way of registered as well as usual within 3 days. In addition to that, the petitioner is directed to take steps by way of dusty upon the respondent number 7 and 8, registered to the routed to the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner is that the petitioner have been enjoying possession over the land covering dag number 833. At village Upaupara in Mongoloi. The respondent authorities, more particularly the respondent number 3 to 6, initiated proceedings under Section 18, Rule 18 of the settlement rules for eviction of the petitioner. And the petitioner duly approached this court by filing a writ, and the petitioner being aggrieved, approached this court by filing a writ petition which was registered and numbered as WPC number 3929/2023. It is seen that this court disposed of the said writ petition by an order dated 25/9/2023, thereby granting liberty to the petitioners to submit individual representations before the district commissioner. So wrong. Within a period of 2 weeks therefrom, and the said authority was directed to dispose of the said representations within a period and not later than 8 weeks. It was also directed that till such time the exercise is carried out and completed, the status quo as regards possession of the petitioners over the plots of land in question be maintained. It is seen that the petitioners immediately thereupon submitted the representations. However, the said representations as per the contents of the petition is yet to be disposed of. In that regard, contempt proceedings have also been initiated by the petitioner being contempt case number 159/2024, which is pending adjudication before this court. In the meantime, while the representations of the petitioners are pending and there exists the order of status quo, an attempt has been made by the what is this PMD? An attempt has been made by the District Commissioner Dorong to settle the land in favor of the respond number 8 and 9. 8 and 9?
7
7 and 8. Hey, Mr. Saikia, how does these have any relevance? The order was passed by this court on 25/9. The communications on the basis of which the respond number 7 and 8 are doing nothing to do with the district magistrates or the whatever may be are prior to that. Can you see? 8/9, 31/8.
25/9.
Where 25/9? Your order is 25/9.
Later dated 20.
How will these people know? You must have got hold of this communication from somewhere. This communication has no relevance to the dispute.
Well, since the land mentioned in the email.
Understood. The district magistrate or the district commissioner took steps even prior to the decision rendered by the coordinate bench. Now, thereafter, they are not doing anything. These are communications of 25/9/2023 and what is the next one? 16/10/2023. Why you are challenging now?
For these two letters, my lord, the process for disposal was not done by the district commissioner. That's why.
Process for what?
Disposal of the individual representative filed by the.
Very good. Stay there. You have, on one hand, not asked for settlement. You should be happy with these two letters. You should frame it in the wall. Yes. Because of these two letters, you are surviving. What do you say? Revenue. Isn't that? Then the district commissioner is not doing anything, not disturbing your possession on the basis thereof. Why you are not going and filing an application for settlement in the format while that is pending? Don't do all these things. I think you withdraw. Yes. The moment I do this, you are in big trouble. Mr. P.J. Saikia, the learned counsel appearing on behalf of the petitioner, submits that taking into account that the actions which were taken by the district commissioner, Dorong, were by issuance of communications dated 31/8/2023 and 8/9/2023 were prior to the order dated 25/9/2023 passed by this court in WPC number 3929/2023, he would not like to press the instant writ petition. Accordingly, the instant petition stands closed on
Regarding the
liberty for what?
if anything adverse.
You are always at liberty. Don't draw anything.
Obliged.
14.
With sincere apology. There's a formal defects in the petition. May I allow, Lordship, may I kindly allow me to withdraw it? I'll refile it.
Hello, Mr. A. Samwad, the learned counsel appearing on behalf of the petitioner submits that there is a formal defect. What is that formal
Well, I
defect?
give two annexes that I failed to annex. my lord.
Submits that there are two enclosures which requires to be brought on record. However, on account of the fact that he however submits that that would entail bringing on record an amendment to the instant writ petition. He therefore submits that he may be permitted to withdraw the instant writ petition and given a liberty to refile by removing those formal defects. Taking into account above, the petition stands closed on withdrawal. Would submit it. However, made clear that the petitioner would be at liberty to refile the petition by removing those formal defects.
I'm obliged.
15.
Wait, please, Lord.
Yes, Mr. Sheikh.
My lord, the land in question, my lord, is a patta land standing in the name of chairman of local board test board. Your lordship will turn to page 22. Let me clear the position. Page 22.
Let us see your representation dated 13/4/2023. Page
Page 77.
70.
77.
Who are you?
My lord, in earlier repetition, my lord, I was respondent number 14.
Who
So
were
what-
supposed
what
to
happened, my
submit the
lord?
representation?
That, Lord,
Who was supposed to submit the representation?
presentation is to be submitted by the earlier repetitioner. She submitted. And 2016, my lord, a notice was issued by the government side that hearing will be take place in 2006 itself. But what happened, my lord, 2006 onwards, my lord, till date, the order passed by your lordship that within 2 months, matter may be decided. And till then, till decision by the government, that status, the respondent number 4, that is myself, should not further construction on the land in question. So from 2006 onwards, my lord, till date, I have a saloon house there. I could not touch that saloon house, and the roof of the saloon house is totally destroyed, my lord. The rainwater percolating to the saloon, my lord.
Where is the High Court's order, this court's order?
Yes, my lord. High Court order I am giving. First, your lordship will turn to case 41. Order dated 23/7/2002. That is at page 40, last one. Order dated 23/7/2002. So here it is said, third Mr. Ujir so and so, my lord, who con. The last paragraph, in the meantime, respondent number 4, that is the writ petitioner before your lordship, is restrained from making further construction in the land of the petitioner till disposal of the petition. It is not.
Then they submitted the representation and that representation has been pending for the last 12 years.
Yes, my lord. Not 12 years, my lord. It is about 18 years. 2006. Your lordship would be pleased to see page 69. Page 69. I am directed to inform you that the date of hearing of the connected petition so and so.
Mr. Sheikh,
On my God,
you do one thing,
my lord.
we'll take care of the government. Don't worry. You get it served to the private respondent.
My lord.
By next month.
By Dosti service, my lord. And what happened, my lord?
And the order to be passed is the dispute between both the petitioner and the private respondent herein being civil in nature, the authorities shall not decide anything. If the parties are interested, they may decide so and so and so. Matter?
Yes, my lord, that is the right way, my lord. And your lordship, in the meantime, that earlier writ petitioner, my lord.
You do
Earlier
that.
writ petitioner also filed a writ petition here before your lordship. That is, number is 1248 of 2024. And on 15/3/2024, she also prayed similar prayer that representation may be disposed of by the government.
And what did that court do?
My lord, the court just issued notice. So, my lord,
That would not help you.
yes, my lord. So, my
Matter
lord,
needs an
both
early
the writ petitions.
Where is the other petitioner counsel?
My lord, counsel, I do not know.
I do one thing, wait. Let me list this matter
Yes,
with the other petition
yes,
on Friday.
my lord. On Friday. Yes, my lord.
And the counsel for that petitioner would be present.
Yes, ma'am. Did the council come?
Huh?
Did the council of their.
Yeah, the counsel will be present
will
so
put
I'll
up
serve it to
some
him.
copy. Yes,
and then get an order passed. I think that is the way out. Okay,
yes, madam.
list the matter on 26/7/2024 along with WPC number.
Along with petition number, my lord, 1248 of 2020. Okay.
I'll dispose of both on that day. Matter will be over.
Actually, it is a private patta land.
No, they must have lost the papers.
Actually, my lord, that
You see, the
No, my lord,
government must have lost
They
the.
did not lose the paper because, my lord, I appear in 2023 on my representation. Again, I filed representation. I appear before them. They locate the file and open the file, but they are not doing anything. again.
You see,
Another 1 year passed. Obliging question.
16.
Here I'm the owner of the land. The land was acquired by Oil India Limited. But the payment has been made with the power of attorney holder, and now they're not invoking the indemnity bond either, which they can invoke. I'm only paying for a notice at this stage, Lordship.
You are entitled from respond number 5.
4 and 5, both. 4 has to invoke the indemnity bond if the 5 doesn't pay. Because it was released against Lordship, from 1 and 5. Because they have
Where's the indemnity?
indemnity bond.
Indemnity bond is where?
Indemnity bond, Lordship, is at 8. They have spoken about it, they have not furnished. Oil just spoke about it. That at page 88. In reply to 77, it is appropriate to that the subject of payment of compensation against land in question, which was a part and parcel of Dhekari Unit 1 Division, this was paid to the said attorney holder, proprietor of this, on execution of an indemnity bond, and therefore a company has already pressed upon the instant issue to your client and attorney holder to resolve the matter. So they have issued an indemnity. Oil can easily invoke the indemnity bond.
It's an indemnity bond.
Yes, against the
How can they invoke?
It was against the payment.
They have to file a suit. If they don't give it.
The issue is otherwise, the power of attorney has been executed by the present petitioner company, admitted. The power of attorney holder came to Oil India Limited on their behalf, and ultimately the NOC for obtaining for the sale permission was taken, sale deed executed, and the money was paid. Now the dispute is the power of attorney holder has cheated them, and the money has not been paid to the original owner. So in my understanding, probably it's a dispute between the power of attorney holder and the original owner who had executed the power of attorney. So Oil has done its part. Oil has made the compensation. They are saying that yes, Oil has made the compensation. But the prayer now is.
So you want to read that the oil should file a suit against respond number 5 for getting the money.
Let the notice go. I think that will solve all the problems. Just a notice.
My obligations I have done. Now it's a dispute between them, for which probably the litigation should not be saddled upon Oil India Limited.
The Lordship, I'm just praying for notice. I think that would solve the problem.
That is the problem. I don't issue notice so easily.
So, Lordship, just a notice, because there's the order from the Deputy Commissioner also, Lordship. There's a meeting which has not been complied with.
What is your, how are you claiming that amount of rupees 1 crore 92 lakhs?
Because I'm the owner, I'm the Pattadar. I'm the Pattadar.
You are the Pattadar. Your land was sold to oil.
Acquired.
By way of a sale deed. By way of a sale deed.
Acquired, Lordship.
No, it was sold or acquired.
Acquired. Acquired, thereafter sale deed was executed.
No, but then also,
By way of
it is
sale.
not an acquisition by
Under the act.
acquisition.
No, it is a sale.
It is a sale.
Yes.
An acquiring by way of sale.
Sale, exactly.
So oil acquired, purchased the land
Yes, Lordship.
and you paid the money.
Yes.
So,
To
Lordship, I
their
think
executed power of
I
attorney
don't
holder.
think we have executed, sale deed was executed, that was done behind my back as far as it was acquired. It was acquired by us.
NOC.
Then if it is done behind the back, isn't the case of a civil suit?
Lordship, just a notice.
No, notice before that.
Just a notice.
These are
Lordship.
clogs in the artery which needs to be cleaned.
No, Lordship, it's just a notice will solve it. Next day, Lordship can dismiss it. Next day, Lordship send me for suit, but right now
I have no objection.
just a notice at this. Next day,
At the end of the day, the problem will be limitation. You have to file the suit against that person.
Lordship, that person, that's a certain technical difficulties, Lordship. So that's why I have come here. Because I feel because there's order from the Deputy Commissioner also, there's a meeting. Acquisition is in the same time.
NOC for sale আছে দেখুন।
Where is the power of attorney?
Annexure 1.
Page
Yes.
19, Lordship.
And
Page 18, it starts at 18.
18.
And clause 10 would be relevant.
And it's acquisition out of line. No, Lordship, you have to read the power of attorney as a whole. This is for the purpose of running the tea state, business of the said tea state.
Clause 10, clause 20, clause 21 would be relevant, Lordship. Clause 10 is to accept SEC. Clause 20 is for obtaining
Accept
sale
SEC.
permission, signing and executing of registration deed. 2021. Yes, sir.
It's an acquisition out of. Now, just a place in it. It's my NOC's accord, because this woman wanted to buy, the attorney holder wanted to buy. What's it given to the attorney holder to buy? No. NOC have to. NOC.
But then this looks like an NOC for
Clearance of necessary. Name of the seller, this.
So when do you want the matter to be dismissed?
And Lordship, let the notice go after 2 weeks.
When? Give me a good date.
After 2 weeks, Lordship.
And let us not have it 2 weeks. Let us have it after winter, October vacation.
Absolutely, Lordship.
Okay. Issue notice making it returnable on 23rd of October 2024. Mr. A. Sharma appears on behalf of the respondent numbers 1, 2, and 3. N. Goswami appears for the respondent number 4. Petitioner is directed to, and as the respondent numbers 1 to 4 are duly represented, extra copies of the petition be furnished to them within 3 days. As regards the respondent number 5, the petitioner is directed to take steps by way of registered as well as usual
oblige, Lordship.
within 3 days.
17.
Lordship, I appear for the petitioner there.
Yes, tell me.
So, my Lordship, this is a GST matter.
Huh?
It's the part of that same batch which was listed before my Lordship on 22nd. And it was adjourned to 26th pending the budget clarification.
Oh, did you get the clarification yesterday?
Yes,
Yesterday, an amendment has become in the budget.
16.4, once section has been proposed to be amendment and the relief has been granted to all the petitioners till 2021, financial year 2021.
Huh?
Financial year 17, 18, 18, 19, 19, 20, 28, 21. Benefits have been given, those who has filed their return up to September, they will be entitled to take ITC. Probably case of the petitions also fall under that.
So this is this covers the batch of petitions which is coming up on Friday.
Yes.
Let's
Majority
have
of
it
the
on Friday.
My
Let
Lordship.
you produce that thing.
Yes.
My Lordship, there is one thing, because as of now, it's only the budget that has been presented. So once it has to receive the assent of the President, so it will go beyond 31st of July. And my due date for filing the appeal is getting over on 31st of July. So I request if my Lords can just issue notice and grant stay like done in similar matters and list it on Friday. Because on Friday, this will be a batch, so I may not
Friday,
get the
I'm
chance.
picking up those matters.
It is listed before Justice
Listed on
Saikia.
All cases will be direct to be listed on Friday.
Yes,
Yes.
I've directed these matters to be listed this Friday.
My Lord. My Lord, sir.
They were 17 to 20.
17, 18, 19.
This is the matter on 26, 7,
17, 18,
2020.
Obliged. It's 18-19 similar issue, man.
And the budget speech, must be there in the budget speech.
Yes,
It is there. It is in the finance bill also, my Lord.
published also.
Huh?
Already
It's in the finance bill also.
amendment has been
It's published.
Okay,
I'll
let's
produce
see,
on that.
because there was a recommendation being given by the
Yes, yes.
GST
Yes,
Council.
sir, yes. That has
It's
been
in the
included.
finance bill, my lord. It is there. Serial number 18 and 19 also, my lord. Same thing.
Okay. On 26/7.
Here, this matter pertains to acquisition of land. Now, what has happened, Lord Chair? I am an inhabitant of the northern side of Kathal Road. In Silchar, there is a Kathal Road, Lord Chair. In both this part of Kathal Road, construction is going on. I will take your lordship to annexation number 18 first. Then I am coming, lordship. Will kindly see page number 107. Public Work Department, improvement of Sierra Avenue to Kachanpur via Chinkor, Tinyali, including RCC drain. Satsang Ashram Road, including RCC drain, both sides. Construction of drain cum footpath at Silchar Kathal Road. Construction of hard shoulder from so and so, so and so, so and so. Now, what has happened, lordship? There was some government wasteland where government would have easily done the construction. First, they have done a survey. According to the survey, the government wasteland was taken into consideration. But later on, what they did, they diverted this survey and they have started doing construction, taking into consideration our patta land. So now we have filed a representation before the DC, lordship, can we see 108, annexation number 19, lordship. 13/2/2024, very specifically stating what has actually happened. Some persons are trying to interfere. If I just read the pertinent part, lordship, paragraph number 2. About 1 year back, measurements were made by the settlement authority and points were earmarked to identify the government land for construction of the drain. However, no construction was initiated. Within a year, a no display board has been installed for any construction work, but it is now witnessed that another process for demarcation of land and going up of place of construction is being initiated. But the entire process seems to be devastated to secure the interests of some people of the locality at the cost of others, completely ignoring the earlier measurement. Efforts are being made to bring the entire road and the drain on our side without attaching of other side of the Kathal Road. I am in the northern part, lordship, and I have annexed all the documents of the 7 petitioners, lordship. You kindly see, these are the patta lands, lordship, all title documents. Some people of the locality are in the constant effort to motivate the LR staff conducting new measurement, and the measurement exercise seems to have been done to accommodate the vested interest of those persons who are trying to motivate the LR staffs and jeopardizing the genuine measurement as was done year back. This resulted to an effort to show the patta land as khas land on the left side of the road and the khas land as patta land on the other side of the road. This is in contrary to the land record and as such an
Why is the RCC drain required?
That's a government project.
Drain for what?
Government project. Lordship may kindly come to
You stay in Kothal Road
Kathal Road, northern side of the Kathal Road. Lordship.
and the other people stay on the southern
Southern
side.
side of the Kathal
So earlier they wanted to have 2 drains.
Road.
Now they are going with 1 drain.
Now they are going to one drain. Now what they are doing in the northern side, they are making my patta land as a center point. Lordship, I have made an averment.
Your
Is our
patta land as
as a center point. They are making a measurement, taking the patta lands as a center point. They are slowly cutting it and coming nearby my patta land. Lordship.
nearby or at your patta land?
Nearby. They have not reached till now. Nearby. So we have given a representation to the DC, asking that whatever was the earlier survey, that should have been done. And if they
So
are
the government now wants to
acquire our land, lordship, it seems, but they have not issued any notice. Our very limited submission is this, that government should do it as per the Land Acquisition Act. That must, lordship. Page 13, if your lordship may kindly take for a moment, lordship. Paragraph number 10, everything is very specifically laid out. Page 13.
Where was the earlier one? Or what is your basis to say that earlier it was on both sides?
Lordship, will kindly see, in that case, the foundation, lordship, the foundation stone, the foundation, annexure 18.
Annexure?
18,
Yeah.
18, page 107.
construction of the drain cum footpath at Silchar Katal Road and construction of hard shoulder from 1500 meters to CH 280 meters connecting the NH bypass.
Page.
Page 107.
Number one, name of the work improvement of CR revenue so and so. Number two, satsang area. Number three, construction of drain cum Iman, hard soldier.
I am here, Lordship, including RCC drain both sides.
Now, why are you saying where is it RCC drain on both sides?
Lordship,
This is Mr. Council. Number two is Satsanga Ashram Road, College Road, point to CR
Including
revenue,
RCC drain
including
both sides.
RCC drain
both
on
sides,
both sides.
Both sides.
This is for another one. We are concerned with construction of drain cum footpath at Silchar Kathal Road
Road.
and construction of hard soldier.
Yes.
Where is it both sides?
Absolute Lordship. This was the earlier.
No, earlier also, now also.
Now what they have done.
Here they have not put it both sides.
Now-
We are
now-
concerned with Kathal Road.
Yes, absolutely. Now what they have done, Lordship, now they have started diverting it. I have made an amendment, Lordship, may kindly
No,
see
environment does not make any sense.
paragraph number 10.
They will,
Lordship, may kindly see.
require, yes, Mr. Mugoi, what do you say?
Yeah, yes, I can have the instruction. As of now, in fact, Lordship has rightly pointed out. In Kathal Road, my lord, nowhere, my lord, it was mentioned that it will be two, now one. My lord. In that case, Lordship, I may kindly submit that I have given a representation. My representation is on record and DC is sitting on it. Let my brother call for a report from the DC. Actuality will come out, what they are trying to do.
You gave the DC on 13/2/2024.
Yes, Lordship.
You knew about this thing is going to happen in 13/2/2024.
24, they have already started, Lordship.
So-
They have already started. Your Lordship, your Lordship.
Then
can-
under such circumstances, why you are approaching in the month of July?
Because Lordship, now they are coming
To
in front of my pattalans. In front of my pattalans, which is making me a concern. Otherwise, I would not have approached your Lordship. I approached first the DC,
There are 7 people,
7 people,
all residing together.
all residing in the northern side of the Kathal Road. At a stress. Northern side of the Kathal Road.
So, so they must have started in 13/2.
Prior to 13/2, they have started, Lordship.
Mr. Gogoi, get your instructions. Lordship. Notice making it returnable on 12th of August.
Lordship.
12th of August 2024. Mr. B. Gogoi appears on behalf of the respondent numbers
One and three.
3. Mr. N. Gusami appears on behalf of the respondent number 2. Taking into account that the respondent numbers 1 to 3 are duly represented, extra copies of the reputation be served upon them during the course of the day. This court directs the issue involved in the petitioners herein are aggrieved by the action taken by the respondent number 1 and 3 in construction of the drain cum footpath on the northern side of the Kathalrad Road, which earlier was to be on the northern and the southern side.
Government Khaslan, Lordship. There are still government Khaslan.
It is the case of the petitioners that in the circumstance, the construction is carried out on the northern side of the Kathal Road. Certain lands of the petitioner would require being acquisitioned, which would cause irreparable, which would affect the petitioners. This court is not inclined to stay the work in question. On the other hand, on the returnable date, the learned counsel appearing on behalf of the PWD, Mr. B. Gogoi, shall obtain instructions in the matter and place it before the court.
Yes, your lordship. Yes, your lordship.
Yes, tell me.
The case of the petitioner here is that her only son died in the year 2019 and leaving behind the petitioner and her daughter-in-law and two minor children. After that, the daughter-in-law in the year 2019 filed a MLCT case in Kokrajhar, and that matter was settled by Lok Adalat in the year 2021 with an award of rupees 14 lakhs. Now, the petitioner here being a 70-year-old lady is claiming at least a sum of amount from the award of rupees 4 lakhs.
Then
Her name was there as a claimant in the net of Kokrajhar.
why haven't you filed any review out there before the local, before the MACT? How a REIT will be maintainable in this matter?
Also, there are judgments which say that it maintainable.
Why? REIT against whom? Whom should we issue the REIT now? Tell me. We should ask the MACT authority now to take over the money from which have been paid to the so and so.
No, Lordship, but we just want it to be distributed to the petitioner.
Understood.
Part of it.
Understood. Why you are not approaching them? That authority. When approach them, tell them that this is order which has been passed is an order, is a fraud order. Yes, Mr. Biswas.
Sorry. The award that has been given jointly has not been given to me. My daughter-in-law has taken it.
So it is a dispute between you and the daughter-in-law. How a REIT court is going to entertain it?
Well, the problem is that when there was an apportion of the amount, my lord, between the 2%, my lord, payment, so my money could not have been released, my lord.
You were not a claimant there.
I was not a claimant, but my name was there.
Where?
As a claimant, my lord, my father, daughter-in-law has made me party for.
Where? In the claim petition, where? What is your
Take
name?
it out to annexure one kindly.
Yes. Where is your name?
My lord, yes, petition, page 13, kindly say, my lord.
So why you are not approaching the authority out there and say that, look here,
My lord, before lordship
if this person had appeared or filed this application wherein my name was duly mentioned, but she was never representing. She could have very well represented the minors, but not the major. So obviously for apportionment of the amount that authority, let the authority pay. They have passed an order for direction of payment of 14 lakhs. So it's directed to pay the awarded amount of and shall be deposited in the name of the Iman in the nationalized bank. So obviously you get this correction out there.
Kindly, if you lordship, your direction will appear, my lord. Because after long delay, if you approach, my lord, they may not entertain our petition.
The instant writ petition heard Mr. S. Biswas, the learned S.C. Biswas, the learned counsel appearing on behalf of the petitioner. the record reveals that the service is duly complete. The petitioner has approached this court being aggrieved by the fact that though the presiding officer Lok Adalat Kokrajhar had directed that the amount is settled at the claim proceedings was settled at rupees 14 lakhs, and there was a direction to be deposited, direction to the insurer to deposit the amount of rupees, to pay the awarded amount within 1 month, and of which 30% of the awarded amount was directed to be kept in the fixed deposit. But the petitioner herein, who admittedly was also a claimant, have not been granted any benefit. This court is of the opinion that the petitioner would be well advised to approach the MAC tribunal, Member Motor Accidents Claims Tribunal, Kokrajhar, apprising the said court that the petitioner being a major, the claimant, her daughter-in-law, Srimati Hemlata Roy, could not have represented her. And in that circumstances, if an application is duly filed, this court directs the Member Motor Accidents Claim Tribunal, after issuing due notice to Srimati Hemlata Roy, to duly consider the same. The said application be filed within a period of 30 days from today, with the above the instant petition stand this court.
This matter can be taken up after some time, Lord.
Why?
Dinner will come, Lord. Mr. Dinner will come.
What is your case?
Yes, well, the husband of the petitioner, my lord, killed by unknown miscreants, my lord. Subsequently, after investigation, my lord, the police had submitted final report, my lord, at page 23 onwards.
Why you are asking for?
Because, my lord, I am entitled at Gracia, my lord, in terms of notification page 13.
Huh?
Page 13, my lord.
On what ground?
Miscreants, my lord.
Why? Miscreants killed it.
Yes, my lord.
Then?
Then, my lord, the FIR, my lord, at page 16. And during pendency of the case, my lord, the deputy commissioner already, my lord, sanctioned the amount and forwarded to the government for approval, my lord. Pardon.
Two lakhs.
5 lakhs.
5 lakhs.
5 lakhs.
Who are you?
I am the wife of the sister.
Wife.
Wife.
My lord, in page 23, the final report submitted by police, there is no mention that the person was killed due to extremist killing.
Vernacular, my lord, page 27.
Actual cause of death could not be recovered. Towards the last.
No, he may not be entitled as per 1511, but
Yes.
wouldn't he be entitled as per the Assam Victims Compensation?
But
my lord, after verification, my lord, the deputy commissioner already accorded sanction, my lord.
Oh, forget about what the deputy commissioner does. I'm asking you whether he would not be entitled as per the Assam victims compensation.
That the state council has to answer. That the GA will respond to that.
Whatever may be, because I think the Assam victims compensation will take care. There's somebody had died. There's no quarrel with that. The final report categorically shows that he's dead.
Dead.
So under such circumstances, let the legal service authority, let him apply before the legal service authority, and the legal service authority will take it. Isn't it?
Otherwise, my lord, 357 now, 396, the new BNSS, my lord.
Why should we go into 396? This happened in long time back.
Yes.
This act will only come into play when?
1st of July.
Then this has nothing to do. I hope. The petitioner heard Mr. M.H. Hussain, M. Hussain, the learned counsel appearing on behalf of the petitioner. Mr. A. Bhattacharjee appears on behalf of the respondent number 1. Mr. N. Goswami appears for the respondent number 3, 4, 5, and 6.
3 also.
Huh?
3 also.
Okay, 3 to 6. None appears on behalf of the finance department on call. The petitioner herein is aggrieved on account of the non-payment of the compensation in terms with the non-payment of the compensation in terms with the notification dated 15/11/2014, to which the petitioner claims to be entitled in view of the death or in view of her husband being killed by miscreants. This court had duly taken note of the documents on record, including the final report, which have been submitted by the investigating officer in connection with which case?
My lord,
Dotma PS case number 1/2020. From a perusal of the final report, it is not seen that there is any opinion rendered by the investigating officer that the death of the petitioner had occurred on account of being killed by some extremist or terrorist miscreants. Or for that matter, that the husband of the petitioner was killed on account of communal ethnic group clashes or due to firing of the security forces. Under such circumstances, in the opinion of this court, the notification dated 15/11/2014 cannot be made applicable to grant the petitioner any relief. Be it as it may, the final report reveals that the husband of the petitioner was killed, was husband of the petitioner. The dead body of the husband of the petitioner was found. And in that regard, a case has been registered under Section 302 of the Indian Penal Code. Under such circumstances, though the petitioner may not be entitled to the benefit in terms with the notification dated 15/11/2014, but in the opinion of this court, the petitioner would be entitled to, but in the opinion of this court, as a crime has been committed, the petitioner would be entitled to compensation in terms with the Assam Victims Compensation Scheme 2012. 2012?
Yes, madam. 18/10/2012 and the latest notification, my lord, 1/2/2019.
Under such circumstances, the petitioner would be well advised to apply before the Legal Services Authority, the District Legal before the Secretary of the District Legal Services Authority, Kokrajhar, who shall duly take into consideration the said application in terms with the Assam Victims Compensation Scheme 2012. Read with the notification dated 1/2/2019. It is observed that if the petitioner duly applies for the said duly applies in terms with the said scheme, the District Legal Services Authority, the Secretary the District Legal Services Authority, Kokrajhar, as well as the State Legal Services Authority, Assam State Legal Service Authority, are both directed to take due consideration of the same and pass appropriate directions and pass appropriate orders, so the petitioner can get the relief in terms with the said scheme. This court grants the liberty to the petitioner to approach this court in the circumstance that within a reasonable time, the petitioner is not granted the benefit in terms with the scheme. Why is the Deputy Commissioner sanctioning these type of issues? They are not supposed to do so. This is when the final report does not say that it has been death on account of miscreants, extremists, or anything. Merely murder case out there, are you going to give benefits? Why don't you ask your Deputy Commissioner to be more careful? This is a sanction being given. Yes, what is this?
Petitioners have been denied compensation on the purported reason that they have encroached few inches of government land. So before I narrate the facts, I would like to clarify, the petitioners are not seeking compensation for acquisition of their land. The compensation is sought in terms of a letter, I'll first, my lord, take your lordship letter at page 34, issued by the respondent number 4, NHIDCL. Before I narrate the facts, page 34 for a moment, kindly. Page 36, my lord, page 36. May I read, my lord? Page 36.
Yes, tell me.
Well, this is a letter to the Kala, the Additional Deputy Commissioner, by the respondent number 4, the General Manager, NHIDCL, inviting a reference on the above mentioned subject. It is to inform that structures lying at the edge of the proposed right-of-way for the subject cited project, the valuation of structures may be measured from the proposed right-of-way till the nearest load-bearing wall column, subject to the safety of the building. So in terms of the letter, my lords, it was decided by the NHIDCL that those structures.
Mr. Monto, why should this court interfere with or entertain this type of litigation? You want that you are entitled to the compensation of the house also.
Not the house, till the next load-bearing column in terms of the letter.
What load-bearing?
The structure of the petitioner, it's a cinema hall.
the proposed right of way falls at the edge of the cinema hall. Land adjacent to the right of way is the patta land of the petitioners. Now, my lords, as per the letter, if the structure is lying at the edge of the right of way, they should be at least compensated till the next load bearing column. Because in any case, my lord, that would, after the project is completed, it would anyways cannot be there or otherwise.
So if this letter is there, why you are not representing before the
I
authority?
already did.
And if they don't do so, why you are not going on terms with section 3D?
Well, it's because it's not
Five
section 5 of the in National Highways Act,
Yeah.
because it is not an acquisition per se as per the National
Huh?
Highways Act. Because there is no 3G notification, the procedures, it's only on the basis of the the letter. And they have already, we have represented and their claim is what had happened, I'll very briefly narrate. Both the petitioners, they are senior citizen they had a cinema hall in their land, which was built in the year 1985.
You want that should be included in the entire multi-story building?
No,
Be
my lords,
included in the
not
declaration in
entire-
terms
not
of
the entire
3D.
multi-story building, whatever.
That's your prayer.
Whatever I'm entitled to in terms of the, now what they say, my lords.
They cannot, Mr. Monto, they cannot pay you a single dime unless it is brought within the ambit of the notification.
They have, my lords, submitted an affidavit. So in fact, the same question what has arisen now, it was my lords, put by the learned single judge when it was listed on the last occasion. The honorable judge had asked the NHIDCL to clarify the basis of this letter. And in terms of that order, they have filed an additional affidavit. May I kindly read it, my lords, what is the additional affidavit filed by them, clarifying the knowledge.
Yes.
My lords, find an additional affidavit filed by the
Page
71, my lord.
page 71. I'll read paragraph 2, my lord. That the, may I read it?
Yes. There are a copy of the affidavit in opposition.
The additional affidavit filed recently by the NHIDCL. Well, its running page is 72 minutes.
When did you file?
Lordship, it was filed.
Oh,
on
got it,
Lordship,
got it.
31/5.
Why do you file it without proper page in 18?
25/6/2014 I filed, my lord.
Yeah. Yes, tell me.
It's paragraph 2, my lord.
The
The writ petitioner in the instant case has annexed a letter dated so and so, issued by the office. This is the same letter, my lord, which I referred to, my lord. Issued by the office of the deponent, whereby it was requested to the additional deputy commissioner and competent authority land acquisition Golaghat, Assam, stating inter alia that the structures lying at the edge of the proposed right of way in the project, the valuation of structures may be measured from the proposed right of way till the next. It should be load, my lord, load bearing column, wall column, subject to the safety of the buildings. The contractor engaged by the office of the deponent for the project has already been appointed and mobilized that site. But due to delay of land acquisition process, the office of the deponent is unable to hand over the land to the EPC contractor. Hence, with respect to the valuation of structures, the concerned department may be instructed to submit the village-wise estimate for the structures at the earliest. What I understand, my lord, from this paragraph.
Lordship, next paragraph 4 is.
So it is not applicable.
So the persons, my lord, whose structures lie at the right of the way, my lord, they are entitled for compensation. This paragraph clarifies it. My lord, read further the next paragraph.
I've read it.
Read it. And paragraph number 4. No,
You have your 7 pillars falls on the
not the
government
7,
land.
not the, exactly. I'll come to that. No, what is their ground, my lord? Now they say, my lord, first, my lord, can I just for a moment refer to the affidavit of the state, my lord, so that there's no disputed facts, my lord. The part of the pillar, that this is the building on the north, my lord. There are 7 pillars, my lord. Part, if a pillar is for, say, my lord, half a feet in breadth, my lord, half of the pillar lies at the perpetually on government land, and half of the pillar and the building is on the patta land of the petition. That is the claim. To clarify that, my lord, it's the stand of the state, my lord. I'll just refer to one paragraph of the state to show that, my lord. If my lord takes up the affidavit filed by the state, my lord, the respondent number 5 and 6 in the instant case. Paragraph 9, my lord. Para 9, my lord.
Yes.
Have it, my lord. That may I repeat? Para 9. Clearly says, my lord, part of the pillar. May I read it, my lord? Para 19.
Part of the pillars.
Yes, part of the pillars. That with regard to the statements made in paragraph 8 of the writ petition, the deponent states that the authorities are not inclined to pay compensation to the petitioners as the land upon which part of the pillars. Now they say part of the pillars, man. It's not the case. Even I'm not endorsing the fact that half of that pillar is on government land. It's not the case that swaths of land has been encroached by the petitioner. Now this is just to point out that only few inches of my lords, according to them, is encroached by the petitioners. Now, next, my lord would take up the affidavit filed by the NHIDCL, which would show that my building is at the edge of the ROW. So there's no disputed questions of fact. Just for a moment, the affidavit filed by the respondent number 4 for a moment.
Page.
Respondent number 4. The running page is
Starts with page 50, my lord. 50.
Page 50. The relevant portion, my lord, would find paragraph 8, page 56. Page 56. Paragraph number 8. May I read it, my lord? Right.
Page?
Page 56, my lord. 56, paragraph 8.
Before that, come to Roman 7.
Yes, I'll come to that. Yes, I'll read Roman 7 first. That the petitioner's contentions are that if the 7 pillars of the said multi-storied RCC building, which falls under the government and are demolished, the remaining part of the building of the superstructure would fall down, and hence the petitioner is entitled for compensation. In this regard, it is reiterated that the petitioner illegally encroached government land and illegally possessing the same. Hence, the petitioner is not entitled for any compensation in respect of construction over government land. Whereas the assessment of compensation is concerned, the land acquisition is being carried out by Kalakam so-and-so under the provisions of the NHI, who has been entrusted by the central government for this purpose. Now, para 8 for a moment. Paragraph 8. That page 56. That with regard to the statements made in para 3 of the writ petition, while denying the same, it is replied that the land of the petitioner was not acquired for the purpose of construction of 4-laning of the National Highway 37. It's an admitted fact, man. My land has not been acquired in Dargaon. As such, there is no question of payment of compensation for demolishing the multi-story building of the petitioner. The land required for conversion of the existing 2-lane configuration of NH 37 into 4-lane is already owned by NHIDCL, is extended up to the edge of the multi-story. My lord would kindly take note, up to the edge of the multi-story building of the petitioner. The extreme right of way of the highway is up to the edge of the multi-story building of the petitioner. Now, from the affidavit filed by
how much land is yours?
My total land is, my lords, 1 bigha, 2 kothas, 5 lessas. So, my lords, 2 things appear, my lords, from the affidavit of
What?
this.
1 bigha, 2 kotha?
1 bigha, 2 kathas, 5 lechas of land.
You have 4 kotha, 16 lechas and 2 kotha, 8 lechas. You have land in 2 dags, 2165 and 2166. One is 4 kotha, 16 lechas and one is 2 kotha, 8 lechas. 4 kotha, 2 kotha, 6 kothas and 16 year 24, one it goes 4 lechas.
Yes.
So it will be 6, 7. 1 bigha, 2 kotha, 4 lechas.
covered by dark number two tags, my lord, under EP number.
2167 and 2166. Okay,
This will just one submission.
not necessary. Circle officer, who is appearing? You. Major, if it is more than that, demolish. Take it
Lordship.
over. From whatever land he is having, his Jamabandi shows that his land is in dark number 2165 and 2166, or patta number 4696. And the total land is 4 bighas, 4 katha 16 lechas and 2 katha 8 lechas. So under such circumstances, if he has more than that, then you go ahead. Because you have come up with some affidavit to that effect, but they are very specific that 7 pillars fall in government land.
Half
You-
part of the pillar.
No,
Seven number
they come up with the part of the pillars. They
No, no.
say only part of the pillar.
Seven-
They are very
seven
specific. They are saying that 7 pillars fall in the government land.
In fact, my lord, they had produced the photographs on the last occasion where it is marked. He also possesses the
We are not
photograph.
concerned, Mr. Mohanto, we are not concerned with all these disputed questions. Let the circle officer make the measurement and report it before this court as to whether the petitioner holds more than any land. And if so, how much portion is in excess. Therefore, with that, the matter is settled. Heard Mr.
Lordship.
P. Mohanto, the learned counsel appearing on behalf of the petitioner.
Lordship,
Mr.
the portion of relevant portion of 7 numbers of pillars, that is, Lordship, kindly peruse the affidavit, page 54 of my affidavit, ma'am.
I've read it. You categorically say that 7 pillars are on government land. And as such, they are not entitled to compensation. As such, that letter on which he relied shall not apply.
Lordship, that letter is for.
That
land-
letter would have applied that if the right of way falls on the edge of the pillars, then in that regard, the compensation has to be paid up till the next pillar. Because there might be a fall of something to that effect. That is the basic way. Your specific statement out there is that he is not entitled to, because those pillars which are there
Over the government.
already are actually in the government land.
Government land.
But that is the matter is otherwise simple.
Yes,
Unnecessary, why should we complicate
so
it?
he's not entitled for any compensation.
The instant writ petition has been
My lord,
filed by the
disposing of
petitioner.
part.
Huh?
Disposing of.
No.
Cadastral mapping is always susceptible to human error. That was my submission, my lord. And one more submission.
I'm Mr. Mohanto. Here is a case, we are not concerned with this cadastral map or anything. Let the circle officer measure it and find out as to whether you are in occupation of any government land and to what extent. And if he comes up with this report, we are believing on that and disposing it of. And if you have anything, go to the civil court. This is the best option, is you should have gone to the civil court. This is not the forum by which you go and decide. You should have filed a civil suit that this is the portion of land they are going to take and thereby I am going to lose. This, your basic contention is, if you demolish these 7 pillars out there, my other portion of the building will fall down. So you are entitled to compensation of that portion. So it is a case of a civil suit. This is not a case by which a writ has to be done. But if they file it on an affidavit, then we have no other option but we are to believe them and the matter ends there. You have nothing to say there.
Municipal taxes have been regularly paid since last 40 years. No one
You
has-
have been paying taxes only on 2165 and 2166, nothing more than that. So if your building is encroaching any other portion of the land, not only that it will be good for breaking out, it will have far-reaching consequences. You are asking a particular portion to that effect. You are now saying that it is at the edge. Let it be in the edge, better off. But the moment you are asking for more, then tomorrow they are saying that it is government land, then they may go for, they will take it over.
I'm not asking for more, my lord. Only as per the letter, my lord. If I'm entitled, if it's at the edge.
The Lordship, we have
grounds of
already,
parity.
earlier occasion, we also, thereafter also, we have joint survey was also carried out, Lordship. And accordingly, circle officer has given the report in the. in my-
Report is there?
Yes, Lordship.
Then we finish it
Lordship,
up. Where is the report?
report not, Lordship, I have stated in my affidavit, Lordship.
No, the
Where is the
report is there
report?
in my writ petition, my lord. Annexure B, page 28, my lord. The writ petition. my lord.
Lordship, paragraph
Should
ten,
we read
Lordship.
the
Paragraph 10 of my
I
affidavit, my lord.
like to state that the applicant so and so have a cinema hall located at so and
Go
so.
page 29.
The cinema hall is located adjacent to the Mana. Part of the cinema is situated in the land which is acquired for expansion of so and so. But the said part is situated in dark number 7164. Said dark number is a government dark. I would like to state your good self that the periodic patta of the land is situated on the back of the row sign fixed by the Imam. So this is already there.
Lordship, and thereafter 7, 10, 21 also, Lordship, paragraph 10 of my affidavit, my lord. Page
Nothing.
57.
Well, we dismiss it. Civil suit. Better you, Mr. Mohanto, go for the civil suit. If I dismiss it, you are finished. You won't get anything.
Yes. Well, in fact, there was an interim order which was passed.
Interim order will get it vacated. Don't worry. That is too small a thing.
The structure was valued, madam. In case the structure was valued by a government approved valuer.
How is it possible? Therefore, your basic case should be that you should go for a civil suit and say that this portion of the land is there. And as such, it falls, and the effect which will be fall upon you. As a, for not inclusion of your land within so and so, you are not entitled to compensation. I will record their submission that you are not entitled because that land is so and so. And say that these are disputed questions for which I give you the permission to go and file a suit. And then you get whatever may be. Because then only you will get that benefit. Mr. Mohanto, I have done a similar matter here as regards, not this matter, a similar matter. It happened out there in the Atgao Bridge. What happened? They were demolishing everywhere. But what they were doing, they were demolishing two of the pillars. Just if you see Atgao flyover out there,
Yes, I see.
there is a what you call a footpath.
Yes, yes.
And on the right hand side, there is a building which is just coming out. So they wanted to demolish that portion of that, the pillars out there. So I got it out there. So I told them that if you want to take it, take it. But this will have the following of those pillars, and as such, you have to pay compensation. He then said that forget about this. I think this is the best way for you to file a suit.
So in that case, my lord, if the civil court decides, my lord, that even the half of the pillar is on my own land, that I'm entitled for compensation in terms of acquisition also?
Absolutely.
And the other
They may go
aspect
for
that are-
acquisition. They may not go for they may go for acquisition of that. This is a question of fact. Because as of now, the circle officer's report is against you.
I was the ground of waiver, my lord, 40 years have passed.
Huh?
No one has ever.
Waiver.
Now all of a sudden they say few inches have been, only a few inches. my
Not
lord.
been said. They are saying about the. They said that those fall. These circle officers' report says that it falls in those pillars fall in 2164. Whereas your building, the land starts from 2165, and 2165 they are not taking 2165 and 2166. In this report, if it is there, you are in more trouble.
My lord, then I'll.
Let me write. Heard Mr. P. Mohanto, the learned counsel, appearing on behalf of the petitioner. Mr. R.K.
R.K. Talukdar, my lord.
R.K. Talukdar appears on behalf of
Respondent number 4, my lord.
NHIDCL.
Yes, my lord.
Mr. N. Dusami appears on behalf of the Deputy Commissioner Golaghat, appears on behalf of the respondent numbers 5 to 7. And Mr. B. Gogoi appears on behalf of the respondent number 8. And so appears on behalf of the respondent number 2 and 3. Itu arrange koi dibo, ha? ঠিক আছে. The petitioner herein has approached this court seeking certain directions upon the respondent authorities for inclusion of a part of its multi-story building within the scope of Section 3D of the National Highways Act 1956, so that that the petitioner is entitled to the compensation. Mr. P. Mohanto, the learned counsel appearing on behalf of the petitioner, drew the attention of this court to a communication issued by the General Manager P. NHIDCL to the additional Deputy Commissioner and competent authority for the land acquisition. In terms with the said communication, it is seen that for the structures lying at the edge of the proposed right-of-way, the valuation of the structures may be measured from the proposed right-of-way till the next nearest load-bearing wall oblique column, subject to the safety of the building oblique structure. It is the case of the petitioner that the respondent authorities, on account of the right-of-way, on account of the acquisition of the right-of-way, which falls on the edge of the petitioner's building. And as such, if any steps are being taken in that regard, the building of the petitioner, the structure of the building of the petitioner would become weak. And any action taken for demolishing of the said pillars would result in weakening the structure of the petitioner's building and would also cause huge loss to the petitioner. Under such circumstances, the petitioner have sought for the relief that the respondent authorities should include a part of the building within the ambit of Section 3D of the National Highways Act 1956, so that the petitioner is given the due compensation. The learned counsel further submits that from a perusal of the affidavit filed by the State Revenue Authority, by the
6 and 7.
Competent authority.
Huh?
Competent authority.
By the competent authority, it would be seen that only a part of the pillars fall in the right of way. And as such, the petitioners are entitled to the compensation. On the other hand, Mr. R.K. Talukdar, the learned counsel appearing on behalf of the NHIDCL, drawing the attention of this court, submitted that the right of way finishes at Dag number 2064. And the petitioner's land, admittedly, is at Dag number 2065 and 2066 of Pata number 639. He submits that from the affidavit so filed, he submits from the affidavit so filed that 7 pillars of the petitioner's building have been constructed on the in Dag number 2064, which is a government land. And as such, the petitioner is not entitled to the compensation in terms with the communication dated 27/10/2020.
That letter was issued not for the petitioner lordship, it was issued over a lordship. In the additional affidavit, I have stated the land whose land is over the private land for that shoot for that letter was issued. That letter was
Understood.
Yes, sir.
You say that it is not applicable.
Yes, sir.
So you are saying that it is not applicable.
Yes, sir.
replying to the said submissions, Mr. P. Mohanto submitted that the said multi-storied building, which had been running as a cinema hall for last 40 years, 40 years, no? Almost 40 years. Even assuming, for argument's sake, as part of the pillars falling, even assuming for argument's sake, but not admitting that falls within the part of a government land, then also the petitioner may not be entitled to the compensation in respect to the land, but for the building, due compensation ought to have been paid. Inasmuch as demolishing of those pillars would affect the structure of the building in question. Mr. Government, you see, in certain matters, if I'm not correct, correct, some people who are encroaching on the government land, you evict them. Then also you pay compensation for the Zirat. And why are they not liable to pay? Maybe they are not entitled to the land, but what about the building? If it is in the government land, but the entire building would be destroyed, you have not taken any action. The government land belongs to you. The land you have given it to them, it's a different thing. But why not about the building? You come up? The last submissions were made by the learned counsel appearing on behalf of the petitioner. In the opinion of this court, requires a further consideration, taking into account that the petitioner may not be entitled to any compensation for the land wherein, even assuming the structures are situated in dark number 2064, which is the government dark. But as to whether the petitioner would be entitled to the compensation in respect to the land, in respect to the structure, which would be duly affected on account of being demolished, on account of the right of way, is a consideration which needs to be looked into. The Revenue Department of the government, the Deputy Commissioner, the competent authority shall submit an affidavit before this court as to why, as to whether the competent authority directs payment of compensation in respect to the Zirat when the NHIDCL as well as the shall file an affidavit as to why, explaining as to why the petitioner herein would not be entitled to the compensation of the house, how in respect to the structure, even if the structures are standing over, some part of the structures are standing over the government land.
Very great.
List the matter again on 12th of August. Because they pay, this government always pays that the jirat for these people. But they don't pay for the land, but they are entitled for a year.
NHIDCL has admitted, apart from the pillar, the rest of the structure is at the edge of the ROW. That has, it's a period.
No, therefore, and in the meantime, the Mr. P. Mohanto shall also file an affidavit as to how much effect would be caused to the building if the structure are demolished.
There is already a report pursuant to the interim order. The court had ordered that valuation should be done by the government and by the petitioners themselves. We have filed an additional affidavit.
No.
If it is damaged, how much damage? I'll again
I'm
put
not
down-
on valuation. I am on effect.
Yes.
There's a difference. A valuation of the building is for them to look into. We are not concerned. But how much building would be affected if the front 7 pillars are demolished?
By an expert, I'll get that opinion.
Yes, obviously, given the liberty to file an affidavit as to how much the structure of the building would be affected if the front 7 pillars of the building is demolished.
Part heard, my lordship.
Absolutely no. I don't have parters. 1, 2 parters. No. Earlier you were running away, now you want a partner. 24.
Very grateful. Thank you.
Wait, is an option.
Yes.
Also, this matter pertains to challenge made by the petitioner wherein the GMC authorities have illegally allowed respondent number 5 to run a go down from their own residential building. Lordship will kindly take up page 24.
Yes, what is your case?
Lordship, here I am aggrieved. Lordship will kindly take up
Why
page
a writ
24.
in the nature of mandamus should not be issued, commanding the respondent number 2 and 3 to act upon the complaint dated so and so and conduct an inquiry as regards the illegal running of the said enterprise owner of the land or the building on which the nuisance exists, to take such measures to prevent removal. What has happened?
Page 24. Kindly. This is a notice given by the GMC. And the 23 is a translated copy.
Since it has come to our notice that you have been operating the above mentioned godown for the last 5 years at Twente, and since the said business is being carried out without obtaining license from the business as per the reasons as to why then
Your lordship, they have what is done, the respondent number 5, they have paid the tax, the assessment has been done, showing it commercial, and if they turned this, the part of the tax, they are paying it commercial wise, but they're using the residential purpose, the ground floor of the residential purpose has gone down. My challenge is to that the license which has been obtained has been illegally obtained because they have failed to give a reply to the show cause notice given by the deputy commissioner. The lordship can take up the affidavit filed by them, the respondent number 5.
so cause was that they didn't have a trade license.
Yes, your lordship. They are
They've taken the trade license.
subsequently after to this by converting the tax assessment of tax, showing it to be commercial, which is by measurement judgment, that is illegal. That cannot be done. If the whole purpose of the building was residential, by paying subsequent tax assessment, you cannot convert it to commercial.
Oh, they made it commercial.
That part of it, your lordship will kindly take up the affidavit filed by them.
Building is given, the
Annexure
permission is
5
given
also.
for residential. But they were using it as commercial, my lord. The assessment people came there and found it to be commercial. So it is assessment, assessed as commercial. Building is for residential. It cannot be, my lord, because you have for resident commercial, you have to hold the entire building, you have to convert it to commercial. That has not been done.
That is my whole case.
Till
And the trade license was taken online. Trade license was taken online.
it. You're using it as a,
My lord, respondent number 5.
you're using it as commercial.
My lord, the fact is that, my lord, in 2015, this lady entrepreneur was using only 100 square meter in his residence for storage of certain goods, my lord, and nothing else. From 15 to 22, There was a no dispute. I was a very good neighbor and he was a good neighbor. Because of the success of this lady entrepreneur, rather I want to say that
What business are you doing?
just storing that, my lord, Huggies and stationery thing in that godown. From there, I supply to the different shops.
Where is your license?
That is, your lordship will find that page. In the additional affidavit, my lord, I have
31 pages. The repetition page 31. Type copy is page 29.
given 43 is the license, my lord.
Page?
Page 43 of the repetition, my lord. My affidavit, my lord. Page 43. The type copy of the license in 2014, my lord. Page 43, annex 1.
Page?
Page 43 of my affidavit, my lord.
43.
Affidavit of respondent number 5.
Yes, what is that? License for what?
My lord, this business for commercial business, that's all.
What business?
Mosumi Chaudhary, my lord. Your lordship got it, my lord.
Huh? What do you do?
Stationaries, my lord.
Lordship will see the original, my lord. Original is clearly stated as stationery.
What does it say?
Stationery.
Stationery item.
Handwritten.
How much is your turnover?
I like small 100 by say around 150 square feet, my lord. There is small room, my lord. That is what I have used as a godown for supplying of those goods to the other shops in the locality, my lord. The locality people also did not raise any objection, but rather they were happy because at the COVID time, they take the things for me also, my lord. Those public has given the representation to the commissioner also. That it is a good shop, my lord, let it there, they supply to us. But my learned friend from 15 to 22 did not raise any objection because he is my neighbor. Very next day, some trouble started, my lord, of the lady entrepreneur between the ladies, and they lost the complaint before the GMC that I am running the business commercially. But it is only a godown, my lord. There is nothing, my lord. Any shop is not there, my lord. Only a storage is there, my lord.
The whole property, the residential property they are using as a go down the ground floor. That is very evident from page 20.
Where are you having your office? I'm asking you.
My office.
Where?
At Bamuni.
Where? In your house?
No, not at my house.
You have taken?
On rent or some other building.
Is it a residential?
Commercial.
Commercial property?
Yes, sir.
The office, the area is a commercial property.
The building is a commercial property. My chamber is at the top. Here, apparently, Lordship, the reply of the respondent 5 shows that they have converted by paying tax. That is illegal, Lordship. The division bench judgment and Lordship judgment, which has been passed, as clearly states there. You cannot do it, Your Lord. Here's the rules. You cannot convert it by paying tax. The recent judgment passed by this honorable court, where Lordship has referred to Sudarshan Reddy, division bench of this court. This particular matter was taken up.
Which one?
Sujata Pathak case.
Huh?
Sujata Pathak case.
What happened?
Lordship, there. The assessment of building to tax cannot legalize an unauthorized construction. That was the principle herein can be used.
Yes, what do you do when there are commercial things being done in a residential area?
Residential, you cannot.
You see,
After
just for example, advocate chamber, you see it. This is also commercial. Let us take out the bigger issue.
advocate chamber, Lordship will have to see the fourth schedule. It comes in the class 1, we have to pay taxes. But,
Understood. Do you seal it?
but there is a stay order, my lord, from this court.
Okay, because if that is stay order is there, why should there not be a stay for them?
But these are residential buildings in a residential areas, my lord. But they use it in a commercially. Commercially means that they are many.
If they are doing major commercial
No,
things,
they may be mixed area, my lord. They have to be used as commercial, but buildings should also be commercial. You have to, under section 18 of the building bylaws of 2014, you convert it to the commercial building and to the business.
how do you convert?
Under section 18 of the building bylaws of 2014, you have to make an application. Then building had to be calculated. The building can be converted into the commercial, subject to changes in the setbacks. If that can be done, there are many buildings in whatever that residential have been converted to commercial and residential. In the Lam Road also, there are many buildings that are doing businesses. Earlier it was residential. They have converted it. Now they are doing business. Since after that,
the building is yours.
Yes, man.
Why you are not converting it?
I will do so. I'm trying, my lord, for conversion.
It will not be possible, Lordship, in that part.
I'm
That part, the area.
You're running the business.
Yes, Your Lordship.
This is
done for
just
another
a small godown, my lord.
Page 16,
This is
17,
no
18.
shop, my lord, only godown, storage.
I give you an opportunity for 3 months.
Yes, my lord.
Else you are going to vacate it.
Yes. This is my
What you
own
have to
house,
do?
my lord,
I dispose it of, giving you 3 months
to convert it.
not to convert. If you fail to do it, vacate it.
Okay.
And if I find another place,
Yes.
that ends.
Yes, lord. My lord, my lord. I agree.
Heard Mr. K. Monto, the legal counsel appearing on behalf of the petitioner. As Gora appears on behalf of the respondent numbers 1, 2, and 3. The so-and-so K. Bhattacharjee
Yes.
appears on behalf of the respondent number 5. The petition has been filed by the petitioner being agreed by an inaction on the part of the respondent numbers 1, 2, and 3 in taking action against the respondent number 5 for carrying out commercial activities from a residential complex. It has been submitted that complaints have been duly filed by the petitioner to the respondent numbers 1, 2, and 3 to conduct an inquiry. However, the respondent authorities, for reasons best known, have not done so, for which the instant writ petition has been filed. Mr. S. Bora, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3 submits that the petitioner herein is carrying on a business in the name of SS Enterprise and have also taken a trade license from the Guwahati Municipal Corporation. Drawing the reference to the building permission and well as also building permission, he submits that the building in question is for residential use. He submits that the petitioner, if so interested in carrying on the business from the said location, can only do so by converting the said building, the use of the building from residential to commercial, which is permissible as per the
Section 18A of the building bylaws of 2024. 2014.
building bylaws of
2014.
section 18A of the The learned counsel appearing on behalf of the respondent number 5 do not deny to the fact that certain commercial activity is being carried out from the building in question. He submits that the court that in a short span of time it would not be possible on the part of the respondent number 5 to immediately search a location or convert the said building from residential use to commercial use. Therefore, he has sought for 3 months' time in that regard. Taking into account the above, this court is of the opinion that the respondent taking into account that the building in question is for residential purpose, the respondent number 5 cannot carry out the business, any sort of business, more particularly the business of a distributorship in the building in question without either seeking conversion, without seeking for conversion of the use of the building from commercial, from residential to commercial. Accordingly, this court also cannot be unmindful of the fact that the respondent number 5 is presently carrying on the business and some time would be required to take appropriate steps for conversion. Under such circumstances, this court disposes of the instant writ petition, thereby directing the respondent number 5 to stop carrying on the business of distributorship in the name of SS Enterprise or any other business from the building in question, which is situated at situated at
Page number 4, house number 2. In number 5,
which is
page number 4, man. Page number, get it clearly.
situated at house number 2, lane number 5, Kamaikha Nagar, Adarbari Timiali, Guwahati 781012. Under such circumstances, this court grants the respondent number 5 to carry on the business, the present business, in the said building, being building number so-and-so, building situated at so-and-so, till 31st of October 2024. 2 months, 3 months. Pursuant thereto, if the petition respondent number 5 would not have not been able to convert the permission of the building from residential, from the use of the building from residential to commercial, the respondent number 5 cannot operate its business of distributorship or any other form of business. It's business of distributorship in the name of SS Enterprise or any other name. It is further directed that in the circumstance the respondent number 5 still continues, the Commissioner GMC shall take due action post 1/11/2024.
All right.
Please. Because of the affidavit not filed earlier, my lord, we will file affidavit in 4 weeks, my lord.
What are you challenging?
Lord, I am challenging a notice of eviction.
So go there. Go there. Why you are challenging here?
Lord, it is a eviction notice, my lord, issued by the railway authorities. And they are required to follow the due procedure of law. That has not been, my lord, followed, my lord.
My lord.
You cannot take action. In the morning I said,
Yes, yes.
if any action has to be taken, it has to be taken under the Assam, the public premises eviction.
No, my lord, notice was given on, my lord, 28th of December 22.
in extra 4 space 35. And that, percentage notice, the interim order was. passed by the
Understood.
Supreme Court.
Unnecessary keeping this matter pending doesn't have any relevance. You want to take action? If it's railway land, take action to the estate officer.
And-
Dispose it of. Unnecessary keeping this matter. Can you improve your case by way of an affidavit? No. The instant writ petition has been filed by the petitioner challenging the notice dated 28/12/2022, whereby the junior engineer works had directed the petitioner to vacate the land, the railway land, on or before 6/1/2023. It is seen that this court, by an order dated 6/1/2023, had stayed the stayed notice on the ground that the same has been done so without following the due process. I've heard Mr. A.R. Bhuiyan, the learned counsel, appearing on behalf of the petitioner, and Mr. K.K. Parasar, the learned counsel, appearing on behalf of the railways. This court duly takes note of that there is a procedure mandated under the provisions of the Public Premises (bracket Eviction of Unauthorized Occupants) (bracket close) Act 1971. For short, the Act of 1971. Act of 71. For eviction from public premises, which includes railway lands. It has been also brought to the attention of this court that there is an estate officer of the NF Railway. Under such circumstances, this court finds no reason as to why the junior engineer works had directed the petitioner to vacate the land. By the impugned notice dated 28/12/2022. So, accordingly, as the said notice, impugned notice dated 28/12/2022 is contrary to the provisions of the is an exercise of power without following the due process. The said impugned notice is interfered with and accordingly set aside. Before parting with the record, this court observes that the setting aside of the impugned notice shall not act as an impediment upon the railway authorities to take action in terms with the provisions of the Public Premises Eviction of Unauthorized Occupants Act 1971. With the above, the instant petition stands disposed.
Yes, Mr. Lordship, in this case, in the morning, Lordship, I am praying for little accommodation. Mr. Didas is some medical emergency, Lordship, he is not well, Lordship. So maybe they can have on next, after 2 weeks, my lord.
Madam, you are appearing for whom?
I'm appearing to respond number 8.
What has happened?
My learned friend perhaps be able to explain. Yes, what has happened is, Your Lordship, that the contention of the petitioners is that the respondent number 8, 9, and 10 have constructed certain buildings on a plot of land which was initially allocated for them to run their shops.
No.
By the petitioners.
No. Petitioners are different persons. Our business are good, hampered because of this construction.
They have certain pharmacy shops on that piece of land, Your Lordship.
Not on that place of land, my lord.
Sorry? Running their pharmacies that are allotted to them by the Gwalior Jilla Parishad to their requirement. Sorry, maybe I'm wrong.
Whose land it is?
That land was allotted for opening of the school, your lordship, and a child development center, my lord. And only that purpose, my lord, that.
Who are you?
We have pharmacies in the adjacent land, my lord. What happened? The respondent 8, 9, and 10 constructed some commercial buildings, my lord, for installment of pharmacies. And we have made complaint. And finally, my lord, a hearing has been conducted by the circle office, and thereafter.
Respondent number 8 is a NGO or
Yes,
something.
we have not, I filed my affidavit saying that we have got nothing to do with the construction part. It is respondent number 9 and 10 who have, if there is any construction, it is as per their, it is their discretion and jurisdiction. It has got nothing to do with us. We only run an early intervention center. There's an agreement between that respondent number 9 and 10 and the respondent number 8, where the respondent number 8's officials go and render services in their premises. That's all that our role is in the entire matter. We have got nothing to do with it. So their contention that we are the ones who are doing something in the matter, that in my respectful submission is absolutely incorrect.
And this land has been allotted to respondent number 9.
My lord, our prayer in the writ petition is that only for implementation of a direction passed by the additional deputy commissioner, which is at page number 53, my lord.
Okay, then we do one thing. We have it with Mr. D. Das being present, taking into account the respondent number 9. So it has been submitted by Mr. R.K. Talukdar, the learned counsel, that he was being informed by Mr. D. Das, the counsel who is representing the respondent number 9 and 10, that on account of personal difficulties, he could not appear today. Taking into account the matter in its entirety, this court adjourns the matter to be listed again on 19th of August 2024.
Can it be 18 or 20, my lord?
Huh?
18 or
18 Sunday you are coming?
20, my lord.
Huh?
20, my lord.
20 is Tuesday. Why should these are too small a matter for a
20
Tuesday?
or 99 or something.
Okay, 21st. 21st? 21st.
Obliged.
Challenge to a notice under 140.
You are challenging on 148.
Yes, Lordship. Because Lordship, the I have been given a notice on 21 for an assessment year of 2013 and 14.
Where?
It's 19. Lordship. In a 147 order.
This is the assessment order.
Assessment order is at page 20. Demand notice has also been issued.
This is not a 148 notice.
It's
19 is there.
19.
Then your question is on the limitation.
Limitation.
Then there is an assessment order passed.
Yes, Lordship.
When? Pursuant thereto.
Person there too. It's
Then? Whereby?
Whereby, Lordship, my income tax has been page 30, page 27 is the operative part.
You have been imposed 4 crores 32 lakhs.
Lordship,
Then?
they are not.
final demand is at page 31. It's 288,4391. 2 crores 88 lakhs. That demand notice, Lordship would find at page 17 also. This is the amount.
This is without penalty. Because here I think return of income assessed at 4 crores 32. Accordingly, so and so, Iman issued demand notice in here. So the demand notice has been issued thereafter. 2 crores 88 lakhs 40,000. Interest. Then what is your ground?
Lordship, ground is that it's beyond limitation, and one other ground I have taken is it's without jurisdiction also.
Don't take that ground.
and-
For taking that ground, you are to submit your return. Without jurisdiction is had means he had no reasons to believe. Isn't it? For that, you fall within, there's a judgment of the Supreme Court which says that you have to first submit your return, then only you can. But here, anyways, the assessment has been done. But why you have approached so late?
And moreover,
Why have you approached so late?
moreover, on
This order was passed on 21/3/2022.
at page 38, I have made my representation where I have not received any notice because my certain accountant died. I also suffered from COVID. My entire family suffered from COVID. Lordship, page 38 is my representation to the income tax officer, where I narrate the whole that I have not received any of the notices.
Yes, madam.
Lordship, we have received instruction, Lordship.
Income tax act. We are concerned with the period from 2013-14. It was exercised in 2021. You produce your records. Produce your records.
Allow us to 3 weeks time, Lordship, for filing affidavit.
Affidavit you file, but also produce records of the assessment. I'm glad. The counsel appearing on behalf of the respondent, Income Tax Department, has sought for time for 3 weeks for filing the reply. For filing the affidavit in opposition. List this matter again on 2nd of September 2024. The affidavit be filed by the Income Tax Department on or before 22nd of August 2024. The petitioner, if so agreed, if so advised, would be at liberty to file their reply by 30th of August 2024. On the next date, the Income Tax Department shall also produce the records of the assessment proceedings, records of the reassessment proceedings which have been assailed in the instant proceedings. Interim order is until further orders.
No courses matter.
No, it is till the next date. Interim order passed earlier shall continue till the next date.
Production list item 1.
Yes, what is this?
My lord, the petitioner cooperative society, my lord, constituted, my lord, in August 2019. And what happened, my lord, they complete the 5 years term, my lord, on 18th of August, my lord, next month, my lord. But they have accordingly, my lord, taken the resolution, my lord, page number 16, my lord, and 14.7, my lord, for holding the election, my lord, on page, my lord, for 16.16.
16.
Yes, ma'am.
Yes.
Taken the resolution, my lord. Resolution number 1, my lord, page number 17, to hold the election on 10th of August, my lord, because the term expires on 18th of August. Accordingly, my lord, tomorrow is the date for publication of the notice, my lord. But subsequently, my lord, due to the current wave of flood, my lord, most of the part, my lord, the shareholders are, my lord, affected by the flood, my lord, for which they have taken a resolution on the next date, my lord, page number 22, my lord. The resolution.
Flood where?
My lord, page number 22.
Where is the flood?
My lord, page number, my lord, 14. 14 is a document, the proof of the, my lord, flood of the area under South Salmara. This is a document, my lord.
Damodar Ghat.
Of the district.
Where is that? Which district?
My lord, district Dubli and South Salmara revenue circle, the petitioner's area, under South Salmara revenue circle, my lord. The flood is there, my lord. And my lord.
Have you published the notice?
No, my lord, it is tomorrow, my lord, for date of publishing the notice, my lord.
Publish. 10th of August. Have it in some good hotel. What do you say?
That's the provision, my lord, under 130A, my lord.
130A is for pandemics.
Yes, no provision, madam, for extension.
This,
It's a mandatory provision.
this will open floodgates.
Yes, open floodgates, correct.
Publish your notice tomorrow. 10th of August, time is there.
18th August, time is there. 18th August.
18th August.
18th August expired date, my lord. 18th August expire, my lord. The term is
So,
expired.
10th of August, give a date. Do it tomorrow.
My lord, due to the members
Nothing doing.
affected
Mr.
by the
Kadir,
flood-
nothing
flood
doing.
water. I have annexed some of the photographs of the area, my lord.
Publish. How do you know on 10th of August you would not be in a position? How many members are there?
And more than 4,000, my lord. More than 4,000.
We'll see when the 4,000 comes. You need 20% only.
10%.
10%. So, very well. 400.
It's 10%, my lord.
Do by video
They have the
conferencing.
right to participate in the election.
Huh?
Members have the right to participate in the elections.
Nothing doing. Publish. Publish.
The registrar, my lord. Approach the registrar, my lord.
Huh?
The registrar, my lord.
You have approached the register. Let the register be clever enough to do whatever it is. I'm not going to do it anything. Because Mr. Kadir, the question is, if I start giving anything here, it'll open floodgates. Every time Assam is full of floods.
That will start here.
Eh?
Flood will start here.
That flood will come here.
Similar case, my lord. Honorable court also in earlier occasions, my lord. 3 months time, my lord.
You see, that is the statutory mandate. Does the court have the power? No,
Only of the 130 AM, my lord, is there.
130 is for them. So I have to direct them that you extend.
Then
Why?
The government,
How can I direct them? It is their discretion.
consider, my lord, my representation.
You end up at a more difficult position. Consider. I don't know. I mean, this court is not a post box. I will give a consideration order when I find that I'm in great difficulty in passing an order. No. What to do? Dismiss. Huh? Withdraw. Mr. M.J. Kadir, the learned counsel. You see, one thing,
Time is
You-
there.
you have time. You publish it tomorrow. On 10th of August, you have time, na? Do something. 10th of August, the floods may recede.
Party, my lord, if anything happens.
Mr. M.J. Kadir, the learned counsel submits that taking into account that the flood situation is presently improving, he would not like to press the instant writ petition. He further submits that the petitioners would be issuing the notice in terms with the provisions of the Assam Cooperative Societies Act 2007 by tomorrow. However, he submits that in the eventuality that holding of the meeting becomes impossible, he may be given the liberty to approach this court. Taking it, holding of the meeting on 10th of August 2024 becomes impossible, he may be given the liberty to this liberty. This court, taking into account the said submission, closes the instant petition on withdrawal. It is observed that in the circumstance, the holding of the meeting becomes beyond the control on account beyond the control of the petitioners. The petitioners would be at liberty to again approach this court.
Time for 1 to 3.
Mr. S.K. Talude appears for respondent number 1 to entry.
We have already communicated that resolution, my lord. So, my lord, the authority, election authority, my lord, my lord, we have submitted the resolution, my lord, of taking the election. Then, my lord, the ARCS or the department authority may, my lord, proceed, my lord, accordingly, my lord, because their part is also there, my lord, to upon the returning officer and adjustment. That may be, my lord, observed.
This court, before parting with the record, this court, however, observes that taking into account that the petitioners have duly informed the officers of the corporation department pursuant to a resolution being passed about the holding of the meeting on 10/8/2024, the corporation department shall provide the necessary aid so that the meeting can be held on 10/8/2000.
Item 28.
Yes, who is appearing for NHI?
File affidavit, we have not constructed a road. This is PW NH division has constructed.
Mr. Talukdar, you are appearing for?
For the deputy commissioner 2 and 3.
Okay. Now, who
My
is
lord,
concerned?
In fact, my lord.
Have you acquired the land?
Yes.
Under what provision?
Under the provisions of highway, national highway.
They issued the 3A notification? 3D?
And subsequently, my lord, there are some subsequent instruction has come to us, my lord, that one part of his land was acquired earlier, that compensation was paid, but for some other part, it was not assessed initially. It was not included in the, my lord, the process. So it was resurveyed and probably, my lord, after that,
How are you exercising 3D, National Highway Act? You can you exercise in the powers under National Highway Act?
Because they are constructing road by National Highway Division. That is where National Highway Act is being followed.
Good, but can they exercise that?
They can, because PW, NH Division, NHA and NHADCL. These key organizations are constructing the route. They also follow TA, TD, TG.
No, why I am saying so? How does these notifications are to be issued by the central government?
Yeah.
And if it is by the central government, how is the state, they are doing it?
Because they have any National Highway Division also.
Understood, but who is initiating the proceedings? Kindly see, competent authority means any person or authority authorized by the central government by notification in the official gazette.
The TA, small a.
To perform the functions of the competent authority for such area as may be specified in the notification. So this notification, the central government has issued a notification for them.
Because that's what they will say, but there is a provision. They can, division also.
No, thereafter the Kala will take it.
Yes.
But the question is whether the Kala has been authorized by the central
But
government.
they are not, that is question will come.
that
Under
of
small
course I
TA.
do not.
He will, they are
No.
internally.
No, everything is by the central government.
Yes.
The state government's rule is nowhere there. Show me your notification whereby central government has appointed Kala for this land. Sir BJ Talukdar,
Well,
show me that notification.
notification is not with me, my lord, but
If that notification is not there, you have no authority to exercise the National Highway Act. At the end of the day, later on, there will be more trouble. Is this matter again on?
I have a communication, lordship, it
From?
reflects that, my lord, from the Kala.
Kala, what does it do? Now, how does the Kala come into the picture here?
Some.
So therefore, this has been done by the central government.
My lord, central government authorized, my lord, the Kala to.
Land has been acquired for ministry, but no, land has been acquired for ministry, it's okay. But whether the ministry has authorized you to act under this act,
My lord, that is
He has to be
possibly we must.
He has to produce T and notification.
Ah,
That T
that this land,
small
because the central government has empowered you, the color to do it. So this act can only be done by this, otherwise it is not possible.
My lord, you will have to notification and.
Let's this matter again on 14th of August 2024, on which date Mr. B.J. Talukar, the learned counsel appearing on behalf of the District Commissioner, which one?
Deputy Commissioner and. two and
Appearing
three.
on behalf of the additional Deputy Commissioner, Revenue and Kala, Dorong Mongoldoy, shall produce the notification under 3 small a
of any setback.
of the National Highway Act 1956, whereby the central government had empowered the had appointed the competent authority in respect to acquisition of the land in which which is the subject matter of the instant proceedings.
Well, may I be because I don't have rule, I file affidavit also. So no NSA. It's like a. It's like a.
We will record your name so that again you get another fees.
Can I have that back? Please?
It is.
14th August. It will have to be- Second one.
This repetition is filed against an insurance company award. The petitioner is an insurance company. We have repeated the claim of respondent number 1 on the ground of misrepresentation of fact and non-disclosure of material information. Thereafter, they went to insurance ombudsman and the award was in favor of respondent number 1.
And
Thereafter, Lordship,
how much amount?
Lordship, 2 lakhs. 14,000.
Yes, Mr. Monique.
Because we say that so far as this is concerned, you had conducted whatever test was required, you had conducted by your own medical team. And therefore, to take a stand that I misrepresent, my husband misrepresented, is not sustainable in law. Number one. And number two, there has been no interim deposit also.
You've got the money?
Did I put it?
Huh?
They did not give me any money.
We have issued a repudiation letter.
You file your affidavit.
No, we have not done that.
File your affidavit.
I'm standing in as a legal aid counsel. Sir.
Huh?
I'm standing in as a legal aid counsel for this matter.
So legal aid
No, I
counsel,
just
you
indicate-
prepare it by your own hand then,
Fine.
and then file it. We will take a handwritten affidavit of Mr. S. Bonit. Otherwise, normally High Court rules permit the type copy. The S. Bonit, the learned counsel representing the respondent number 1 is given the liberty to file the affidavit on behalf of the respondent. The matter again on 28th of August 2020.
Not. Can you see, there are 2 schedules, madam, in the petition, madam. Schedule A and Schedule B. The petitioner, my lord, is the absolute owner of the Schedule A land.
You've been dispossessed
Yes.
by
By an order of the circle officer, my lord. If the lordship will kindly see the notice at page number 33. Page number 33. There are two notices issued. This notice was issued to the police station. May I read, my lord? উপৰোক্ত বিষয় মৰ্মে সন্মান সহকাৰে জনাও যে বকু ৰাজহ চক্ৰৰ বকু মৌজাৰ টুকুৰাপাৰা গাঁৱৰ দিলীপ ৰাভা সোয়েঞ্চো গাঁও ফেৰাজ মাৰিপাত্তা 190 নম্বৰ পত্তাৰ 60 নম্বৰ ডাগত কথা 6 লেচা জমি আমিনগাঁও মুন্সিপ আদালতৰ 30/9/19 তাৰিখৰ হুকুম মৰ্মে দখল সমজাই দিয়া হয়। So they relied on a judgment passed by the civil court for directing the respondent number 4 to hand over the possession of the land to the respondent number 4. But if you now lordship kindly see the judgment at page number 26, the operative portion of the judgment of the trial.
No. Whether there is an execution proceedings.
No. Because not only the suit was.
Yes, circle officer, what are you doing?
Thereafter, the circle officer was given personal appearance. He could not explain, and he said that what the earlier that the Dane circle officer did, he could not say. Thereafter, they filed an affidavit. If your lordship may kindly see the affidavit.
It was filed by the deputy commissioner.
Affidavit, my lord, at page number 36, para number 4.
Para number
4. That the respondents are not aware and could not be understood from the records available in the office as to why the Dane circle officer Bokor Avenue Circle passed an order to hand over the possession of a plot of land so and so to one, namely Dilip Rava. There was no judgment passed by or there was no direction to the circle officer to do anything. Not only the suit was dismissed, the counterclaim was also dismissed.
The council, you make Dipsika Soikia party
in this petition.
Is the circle officer, na, by name. If necessary, file amendment, file something, because she did it beyond what is there.
Yes.
Because the thing is, the state government, whether she did it on her own force or she had done it in exercise of the powers, exercise as a circle officer, it is another thing. Who is appearing for this Dilip Kumar Rava?
From the
You are not in possession now.
No. And the most interesting thing is that.
And what is the order passed by the Munsif?
Yes, that is at page number 40. Page number 26. Page number 26 of
Who filed the suit?
I filed this.
For what?
For declaration of my right title interest over the schedule B land.
For adverse persons.
Suit is dismissed without cause. Counterclaim is also dismissed. He said that he had purchased it from somebody. So he could not prove that deed or whatever, and accordingly his counterclaim was also dismissed. But the circle officer relied on the judgment to evict the petitioner from the disputed land.
Counterclaim dismissed, suit dismissed.
Yes.
And the possession is with Dilip Rava.
Yes. He sought for recovery of possession in his counterclaim.
When were you evicted?
On 1st of February 2021.
And why you are coming in 2023?
No, because he was sick and apparently after that we also had to file a first appeal. This person, petitioner, he is suffering from cancer and so several reasons. He could not come up and then his first appeal was also delayed. So now we have filed a condonation application as well as the first appeal which is pending before the Court of Civil Judge, Amengaon. But they have not preferred any appeal against the counterclaim.
But isn't it too delayed?
Well, we are only on that action of the circle officer as to how he could have relied on the judgment for evicting us or for directing us to hand over the position to the respondent of court. Because he relied on the judgment.
No, he directed you.
Yes.
How did you, and you handed over?
Yes, because that notice.
You handed over?
Yes, because that notice was also to the police person. So police person along with the officers of the circle officer, they came and took the position.
And you handed over the position to whom?
The respondent number 4.
Yes. Your fault. He may issue a notice. That's a different thing.
Yes.
But the question is, why did you hand over?
Can we say that we were forcefully responding?
File a suit. How can it be you hand over? Suit for recovery. You handed yourself has handed over voluntarily.
If your lordship will see the last notice, one notice was also issued to the officer in charge of the local police station. That means they wanted force, whereas there was no report whatsoever that there was any kind of restraint or any kind of activity from the petitioner side.
You have to file now a suit for recovery.
But ours appeal is already pending, challenging.
That is a suit for adverse possession.
Yes.
Now, but then also you were in possession.
Yes.
Your suit was dismissed on the ground of on the basis of the judgment passed in 2019.
Yes.
Now, the recent in 2023, the Constitution bench held that adverse possession can also be a suit.
Yes.
So, under such circumstances, now don't you think that you have a right?
Trial court also did not say that just because we have preferred a suit for adverse possession on the basis of adverse possession, our suit should go. The trial court had that since we are already in possession, so we should not
No,
any further.
the trial court referred to Ravindra Kumar Gerwal and said a suit for adverse possession cannot lie.
Yes.
Then you have not read your file properly.
If the lordship will see,
I've seen it.
considering page number 24, considering the law laid down by the Honorable Apex
No
Court,
one can help you people.
it appears that there is no bar for a person to bring a suit as a plaintiff in respect of the land over which he claims to have acquired title. by
Kindly
way-
come to paragraph 9.
Yes, I'm reading paragraph.
Now the settled position of law is that respect that a law laid down by so and so, it has been held that we hold that a person is so and so is a man is over and ever owner to eject him and lost and as such so and so in so and so. Yeah. In a case of dispossession by the owner having right to so and so, similarly a person is so and so. Similarly other articles also in similar. Considering the law that it appears that no bar for the way to bring a suit for him. Seems to have acquired title by way of adverse against another to the test from which he has acquired title. Here's the plenary initiative. No one can help you. The client can't be helped. I would have understood the state had got the possession. But you handed over the possession to Dilip Das. Dilip Raga.
Yes.
How can you help it? I would have understood you handed over to the circle officer. Circle officer handed over there. But you gave it to the circle.
So apparently,
And you are challenging the circle officer's thing.
yes, because apparently the position now is with the respondent number 4.
The council, this is a case for dismissal. Not in my hands today. I can't help you with this. When you made the mistake, what to do? You could have very well challenged that document. How could the circle officer have given you by yourself voluntarily handed over, rightly or wrongly? And now you want that the state should recover it from Dilip Prabha. and then give it to him.
Yes.
Although it belongs to Dilip Prabha. Because your claim is of adverse possession.
Yes, yes,
Adverse possession has to be against Dilip Prabha.
Yes.
So under such a, from the rightful owner, the state will take over and give it to you.
yes, because the state was involved when the possession was handed over to respondent number 4.
State had issued a notice,
Yes,
rightly or wrongly.
yes.
So you did not challenge it. Can't help it.
Left papers on that. I'll obtain instruction then.
Instruction for what? You need to file a suit. And do you want to further delay it? File a suit. Make that person a party by name. Dipshika. There's no way out. Problem arises because of that. At the request of the matter, counsel for the petitioner, matter stands adjourned to be listed after 3 weeks. I don't fix a date in this matter.
You want?
Lordship, our affidavit is ready to be filed. We'll be filing within a
Your
day or two. Affidavit.
affidavit.
Yes, ma'am.
What is the matter, Mr. Ali?
Regarding my lord, conversion of land, my lord. And we were in position and our father's name was recorded, my lord, in the land. Admittedly government land, my lord.
Mr. B.J. Talukdar, the counsel appearing on behalf of the respondent, Deputy District Commissioner, submits that the affidavit is ready and to be filed within a week's time. To list the matter again on 28th of August 2024, the affidavit on 28th of August 2024, the affidavit of the respondents be filed on or before 19th of August 2024. The petitioner, if so advised, would be at liberty to file the reply.
32.
Yes, what is this?
Yes, ma'am. This is the into notification dated 3rd of February 2023. The petition that I had filed before the learned DC seeking cancellation of next of kin has been kept in abeyance pending the disposal of a succession matter, which has been filed by the private respondents. If my lord is pleased to see page 39, that is the order of this honorable court. This is the first round of litigation, my lord, at page 39. This will more or less give the facts of the matter at page 40, if I may.
Then what happened?
Yes, my lord. By virtue of this, direction was given to the learned DC to dispose of my application. Thereafter, since no response was forthcoming, I was constrained to file a contempt petition that my lord will find at page 44. At page 44, this is the order of this honorable court dated 19/7/23.
Who is appearing for the respondent?
Before, I'm pointing out just one thing, but kindly lordship will have a look at page 40, my lord. I'm appearing for respondent number 1 and 2, state respondents.
40.
Yes, page 14. Absolutely on incorrect statement. Earlier occasion, he obtained the order, my lord, of this honorable court. Earlier. Internal is 40. Earlier, that is the operative person, my lord.
No. Mr. Goswami, whether the matter is pending before the probate court.
That will.
I'm asking you that because that is the reason why it has been kept in abeyance. Whether it is pending.
But in
That has
any
been
case,
disposed of. Now that case has been disposed of last month, my lord, on 21st of June. It
What
has
have-
been dismissed. The succession certificate has not been allowed. It was filed by the private respondents.
two
And
issues
that
are
is
different,
that-
my lord.
that is at
Two
page
issues
one-
are different, my lord. One succession certificate, this is next kin certificate, my lord. Next on kin certificate, my lord. The petitioner, what he has claimed, my lord. Lordship,
Mr.
kindly have a
Goswami,
look,
kindly appreciate one thing.
my lord.
This order has to be tested on the reasons which have been given.
My lord.
The reason is that they have kept this order in the application filed by them in suspension in view of the pendency of the succession certificate. Now the succession certificate application has been dismissed.
My lord.
So isn't it required for the assistant commissioner now to take a decision and pass an order?
That will do. But that will do, my lord. What they have done, my lord, at least that part your lordship will kindly see, my lord. I am pointing out, my lord, how he has approached this honorable court, my lord, with unclean hands. Lordship will see, my lord. He, on the death of his father, Adilur Rahman, he was, my lord, the petitioner father was not Adilur Rahman. He, my lord, obtained this order, my lord, by
Mr.
saying, yes, yes, I
Goswami,
understood, my lord. Lordship,
kindly don't convert this court to the court of the assistant commissioner and BO Kamrup Metropolitan.
No,
Let
that I
that,
understand.
let that authority decide. The authority here, he is challenging page 46.
Please, my lord.
Succession certificate proceedings is over. Let this authority now decide. That's all. What is there?
That will be done, my lord. But he has not come with clean hands, that I am pointing.
Clean? He is challenging this.
Yes.
He did not come with.
He obtained the order,
He,
my lord, without.
Mr. Goswami, he did not come with clean hands before Justice Buzarbura. Justice Buzarbura has passed the order and has also retired. Now we are concerned with 46.
Not only just,
46 is the matter out here.
my lord, not only Justice Bujor Borua, my lord, even before this court, when the present writ petition, which is before your lordship, my lord, listed as item number 32. In this case also, my lord, they have misled this court.
Paragraph 2, my lord.
My lord will see paragraph 2 of this writ petition. What is their statement?
Yes.
Now. Writ petition or?
That is the basis, my lord.
Page number 6, my lord. That the germane facts of the instant case is that the father of the petitioner, namely late Adidul Rahman. My lord, let them make a statement before your lordship that he is the son of Adidul Rahman. My lord, I don't have any. I'll not make any submission. Not only this, my lord. My lord will see their cause title in this case, where she has the cause title, page number 4. Mr. Atidur Rahman, son of late Rumena Rahman, doesn't write the name of his father. Here at para 2, he is projecting his brother as his father.
Brother?
Yes.
This is a typographical error. This is a typographical error.
Who is the brother?
I am the brother. Atikur Rahman, the petitioner before my lord, is the brother of late Shri Adilur Rahman. Is the brother. But for some reason, it was mentioned as father, and that has continued throughout the.
Rumena Rahman, not a lady.
Rumena Rahman is the mother of. late
What is
Shri
the
Adilur-
father's name?
Father's name, my lord, it is Abidul Rahman. So that
Why
is
you
not-
have not recognized yourself with the father? Means,
I am the brother. This is a
no,
typographical
in your
error.
affidavit also, you have not recognized yourself with the father.
That particular difficulty is there.
Why? This is not a difficulty. It
Yes.
seems to be something
Some purpose.
more clever. A clever drafting?
Sir, I have not drawn the petition, unfortunately. I am the.
Whoever it is,
Yes.
you are appearing for
I
the
understand
petitioner.
that.
I'm not concerned who is drawing it.
I
or not.
understand.
But how is it?
I understand. That is.
And why have you then mentioned it to be the father?
I am the brother of late Shri Adilur Rahman.
Huh.
And that is a factum.
Now, whose next of kin certificate?
The next of kin certificate has been issued.
Of
in favor
Adilur Rahman.
Of late Shri Adilur Rahman. In favor
Adilur
of
Rahman.
respondent.
Now you admit Adilur Rahman is not your father.
He is my brother.
He's a brother.
Yes.
So you want your name also as a brother?
Precisely.
Where is your application that you want your name as a brother?
Application before the.
Show me that.
Is at page 21.
Huh?
Page 21 it starts.
Huh.
This is the application that I had filed before the learner DC.
Page?
Page 21. Forming a part of Annexure 3, my lord.
Yes.
Petitioner is Atikur Rahman,
Hmm.
son of late Rumaina Rahman. Versus Afroza Rahman, respond number 3. And Azana Rahman is respond number 4.
Now, why your name should be included in the next of kin?
If my lord may permit me to draw
How
my
do you
lord's
get a
attention at
succession?
page 32.
No,
Yes,
why
yes.
your name should be included?
My lord, by virtue of this, of the next of kin certificate, certain transfer of shares have been effected in the company wherein all of us are shareholders. It's a private limited company. In my respectful submission, the next of kin will not be just limited to the private respondents, but the scope will also expand to the first set of family members under the Islamic laws.
Are you the first set?
I will fall as a brother. I will,
No. Brother, how will the brother come in?
in fact, as per the Islamic law, my lord, the ratio in which the division has to be made, my right is at the top, in fact.
How?
That is as per the Islamic law table. If
To me?
I have not annexed it here.
Don't come up with before this court without knowing that. You come under the Hanafi law
Yes, my lord.
or the Shia law?
So this will be under the Shia law.
Absolutely no. It is a case of Hanafi law. It's a case of Sunni. These people are Sunni people. Where do you file Shia people? Some people are there in Bombay, rest in Iraq. Then this will come under the Hanafi law. If it is a Hanafi law, it will the son who there are two. One is the son and the daughter.
Daughter and the wife.
The wife of the deceased and the
Daughter of the
niece, that
deceased.
is the daughter.
Daughter.
Yes.
So the wife will get 1/8, remaining that so the daughter will get when there is no son. That's the law. How does the brother come in?
But
Then
my lord, my only small relief is that the application be decided in terms of the Honorable High Court's order. My appeal against the issuance of next of kin has to be decided by the learned DC. I am only pressing.
anyways, whatever may be, Mr. Gusla. Huh?
That is the basis which I have pointed out, my lord.
No, understood, whatever may be, Mr. Goswami. But the thing is, it was kept in he has filed an application. His application has been kept in abeyance on account of the disposal of the succession proceeding. Now the succession proceedings have been disposed of. So under such circumstances, let the authority take a call.
That part is there, my lord.
So,
Only thing, my lord, how the petitioner came before lordship. my
Ah,
lord.
let
Lordship has
us
seen,
be.
my lord.
Not only that, my lord, if your lordship sees his application,
Entirely based on the, my lord, the incorrect statement, my lord, he obtained this order.
if your lordship sees his application before the deputy commissioner, your lordship will see very conveniently, he has not disclosed the relations of the legal heir with the deceased. Now, my lord, these are the certain things which are raising eyebrows. Not only once, he has given a wrong affidavit.
First, you are being assisted by?
Oh, my lord, I am.
You are being assisted by him. Ask
Yes.
him to go and explain it before the authority. If you have no time to go. Okay, let us finish off this matter. The instant writ petition has been filed by the petitioner challenging the order dated, what is the date? 3/2/2013, 23, passed by the Assistant Commissioner and BO, Kamrup Metropolitan District, Guwahati. Isn't that the order you are challenging?
It's a communication at page 46.
The communication dated so and so. A perusal of the, I've heard Mr. N. Das, the learned counsel, appearing on behalf of the petitioner. Mr. Government.
No, I'm putting state.
It has been so. Mr. B. Goswami, the learned additional advocate general, appears on behalf of the respondent number 1 and 2. Mr. M. Biswas appears on behalf of the respondent number 3 and 4. It has been brought, this court have duly perused the order dated, the communication dated 3/2/2023. From a perusal of the said communication, as well as the materials on record, it reveals that the subdivisional officer S, Kamrup Metropolitan District, had issued a next of kin certificate in favor of the respondent number 3 and 4 on 26/3/2013.
2023.
13. The said no objection certificate, no next of kin certificate has been put to challenge by filing an application before the District Commissioner, Kamrup Metro. On account of certain orders not being, on account of no orders being passed in the said proceedings, a writ petition was filed before this court, which was registered and numbered as WPC number 6597/2022. This court, by an order dated 26/10/2022, directed the additional deputy commissioner to dispose of the said proceedings within 1 month from the receipt of the certified copy of the order by providing a hearing in the proceeding. Within 1 month from the receipt of the certified copy of the order, provided the hearing in the proceeding is already over. Thereupon, it is seen that on account of non-compliance to the order, a contempt proceedings was filed, being contempt case number 786/2022. The said contempt proceedings were, however, closed by an order dated 19/7/2023, inasmuch as the impugned communication dated 3/2/2023 was placed before this court, showing compliance. This order dated 3/2/2000, this communication dated 3/2/2023 have been assailed in the instant proceedings. This court takes note of the contents of the impugned order, which shows that in view of the pendency of succession case number 186/2013 before the learned court of the district judge Kamrup Metro at Guwahati, the application so filed by the petitioner for cancellation of the next of kin certificate dated 26/3/2013 was kept in abeyance. Pusto. It has been submitted at the bar by the counsels appearing on behalf of both the parties that the proceedings being succession case number 186/2013 has already been disposed of. Pusto. Under such circumstances, this court is of the opinion that the authority concerned, that is the respondent number 2, can now take up the said application for cancellation of the next of kin certificate for disposal in terms with the directions so passed by this court in its order dated 26/10/2022 in WPC number 6597/2022. Accordingly, the petition stands disposed with the above observations and directions. Before parting with the record, this court, however, finds it very pertinent to observe that the counsels appearing on behalf of the respondent state as well as the respondent number private respondent submitted that the petitioner herein has no right whatsoever over the properties belonging to late, what is his name? Adilur Rahman. Taking into account that this is a writ court, it would not be proper on the part of this court to decide the said respect. However, liberty is given to the private respondents to agitate the said respect to the matter before the respondent number 2.
I'm not on property, I'm only NOP. No objection certificate, that part.
Has no right over the property.
know the case
Property
number.
include the shares also.
I know the case number is 136/2013. It has come as 186. It's 136. I'm sorry.
Yes, what is this? Global Modern Academy, Boroland.
In this case, Lordship,
Oh, you Mr. Boroland now this?
I am respondent, Lordship.
Oh, tell me.
My land. He occupied, Lordships. It was given on lease, but now forcefully occupied and running a school, private school.
Anyways, affidavits, everything filed?
The BTC has not filed their
Yes, BTC,
Record will be recorded.
records required.
Because
BTC, are you filing affidavits?
So I am filing affidavit, my lord. Let it come after 2 weeks, my lord, because I am not in this case, my lord. R. Musahari is in the bus. He is some personal difficulty. He is not here.
Anyways, you file your affidavit. We'll find it, we'll fix it in the month of, on 6th of September.
Not
List the matter on 6th of September. Good stop. The BTC shall file their affidavits in opposition on or before 27th of August 2024. The petitioner, if so advised, would be at liberty to file their reply.
the records may be called for because.
Record we will see when the matter is taken up.
Lordship, interim order.
Interim order passed earlier shall continue till the next date. Yes.
Yeah, Vijay Lordship. Under the fact of the case is that, my lord, the petitioner purchased a plot of land, my lord. Thereafter, he obtained a permission from the GMD, my lord. Silchar Development Authority, my lord, SMG. Thereafter, my lord, the plot was situated nearby the NIT Silchar, my lord.
NIT?
Silchar, my lord.
Silchar. Okay.
The NIT, my lord, stop the works, my lord, petitioner building.
Who stopped?
Security of the NIT, my lord. Security of the security forces of the NIT.
Security forces of the NIT.
And under this time of the register, my lord. According to your 5 days.
What is this NIT?
Definitely Institute of Technology, my lord.
What is this? Why you are not filing a civil suit? What is all these things, filing a writ out here? Tell me. Whether the securities have done it or not, how do we know?
By the eventual before the deputy commissioner also, my lord.
Isn't it a private dispute between both of you?
No, no, my lord. First is the plot of land, my lord. Then-
Understood. If he is disturbing it or he have stopped it, why should I issue a writ? Tell me. Don't you require a permanent injunction from him? That he should not disturb? Then how can this court agitate all these things?
So the with your disobservation.
Huh?
And the disobservation will be lost.
What?
The disobservation will dispose of, my lord.
Ah. Great. What is this National Institute of Technology? Under what? Government of India?
Yeah, it is, my lord, I am for respondent number 3, Silchar Development of Road.
Yes.
My senior Mr. SP Chaudhary is for respondent.
Who is for respondent number 4?
Mr. SP Chaudhary, sir. Mr. SP Chaudhary.
Your senior?
Yes, my sir.
So you are both in hand in glove.
No, my lord.
Then?
I am the authority which issues
You issue the certificate.
for the.
You give
I have
him
given
the
the
year.
certificate. Yes, sir.
But your senior has now representing in and as such, you have some problem.
My lord, that aspect, my lord, page number 10, it is all mentioned there, where there is a dispute regarding that particular land. He himself had mentioned that there was a title suit file and accordingly, some plot of share was actually been given to the NIT. Page number 10, point number 8, my lord.
Lekhok, heard Mr. Swenso, the learned counsel, appearing on behalf of the petitioner. And Mr.
K. Vishwakarma.
K. Vishwakarma, appearing on behalf of the respondent number 3. Mr. A. Bhattacharjee appears on behalf of the respondent number 1. And Mr. S. Borua appears on behalf of the respondent number 2. I do 1, 2, 3 ঠিক করে দিব, হ্যাঁ? ঠিক আছে. None appears on behalf of the respondent number 4. The case writ petition has been filed by the petitioner being aggrieved by the action on the part of the respondent number 4 in not permitting the petitioner to carry out construction of the building, in spite of the fact that the petitioner herein has the due permission, is the owner of the land and has due permission to construct thereupon.
Page 54, my lord.
This court is of the opinion that the dispute between the petitioner and the respondent number 4 is a private dispute between the said, is a private dispute. And there is no public law element involved. Under such circumstances, this court is not inclined to entertain the instant writ petition under Article 2 to 6 of the Constitution. Be that as it may, the petitioner herein is, however, given the liberty to file, is always at liberty to file a suit seeking appropriate declaration and injunction if so advised. Petition disposed.
I oblige, sir.
5 and 36.
Yes, Mr. D. Gogoi.
But in this case, I appear for the NHIDCL, my lord.
Oh,
Two cases has been
NHIDCL.
entrusted to me.
Then?
This is a case, my lord. They would say I am a party who has no interest, but I am the person who, the party who will acquire the highway. And my lord, they have filed one after coming to know, my lord, that the highway will be acquired.
One thing very nice about Mr. D. Gogoi is, you are the first NHIDCL council who comes up and says that we have an interest in the matter. Normally, NHIDCL says NHAI, NHAI says NHIDCL. Now you are the only council. Now come on. Yes, tell me.
Well, let them present the case.
Huh?
Let them present the case.
My lord,
Yes, please, your lordship.
Yeah, affidavits filed.
Affidavits filed, my lord. But my lord, there's an order of 18-6. Some
Hmm.
additional information was asked by.
18-6.
18-6.
What is that?
The DC was to clarify something, my lord. Mr. Hendrik was appearing.
Then shall produce the relevant records in respect of the impugn order dated 8/1/2024. Where is that order?
In order at page 80, my lord.
Page 80.
80, annexer 9, in the first case, my lord.
In pursuance to the from the remand, the 19 numbers of appeal for reclassification of land under so and so approved in non-remand in the conference. You are challenging this?
I'm challenging this, my lord. In fact, my lord, what has happened? There is a state legislation for reclassification of land from agricultural, my lord, to industrial land. Now, the deputy commissioner is the authority who will decide either accord the approval, my lord, or refuse it. My lord. Now, what had happened, the procedure which is prescribed under the state legislation, my lord, that was followed. And pursuant that.
Have you got the records? Who was appearing?
The last time petitioner took time. 18-6 of handicraft.
Whether the records will be necessary?
But I don't think, because the question of law is involved. Here, what has happened, what I'm trying to say, that apparently from this order, it appears that the deputy commissioner, on the advice of the NHI DCL, had cancelled, my lord, the reclassification process. And if your lordship sees the statute, state legislation, my lord, it is the deputy commissioner who will exercise his discretion. The NHI DCL does not come into the picture. So therefore, here is a case, my lord, the deputy commissioner has abdicated his power, or essentially he did not apply his mind, my lord. Because on the advice of the NHI DCL, my lord, he has, my lord, cancelled this process, my lord. And apparently that could not have been done.
If the reclassification happens, the value of the land will go up.
Exactly. Exactly.
That is correct. But what I'm trying to say, my lord, here your lordship will see the process, my lord, had come into, my lord, conclusion, or it had culminated before the 3A notification. Admittedly, I can give your lordships the date.
No. Whether the 3A notification has been issued.
3A notification issued, my lord, on 18/1/24, showing, my lord, the present, my lord, land as industrial land. Pursuant to this reclassification process, it has been shown as industrial land.
And then?
Industrial land.
So you get more money.
Now, what has happened, my lord, without giving opportunity under 3C, when the 3D was, my lord, issued, again it had been converted into agricultural land.
So wrongly issued.
Due to, my lord, this.
Actually, as per the land records, what was it?
The deputy commissioner, my lord, accorded the in principle approval in terms of the state legislation, my lord, 2015. And the land was converted to industrial land. And that is, my lord, on 2012-23. 23 itself.
It was converted.
Yes.
It cannot be converted by the deputy commissioner. It has to have the sanction of the government. You are referring to the 1936 Act.
No, 2015 Act, my lord.
What does it say?
My lord, there is an affidavit of the respondent too, your lordship will find, which was at page 106, my lord.
Yes. Anyway, all these things can be very well taken under 3G. Why are you not taking up all these things? But this is the industrial land and whatnot. And as such, I am entitled to the compensation, which was later on reclassified under 3C to be the residential land or agricultural land, thereby reducing my compensation. Take up all these things under 3G. What is this court is going to do?
In fact, my lord, there is a provision for appeal under the same act which they had applied, my lords. And that act also says, my lords, this transaction is motivated because, my lords, after obtaining a clearance for a non-agriculture activity, that land has to be utilized for non-agriculture activity within 3 years.
which is never going to see the day because the highway is coming on that side. It's a motivated transaction, my lords. To extract.
That I know.
Yes, my lords.
The moment he said I knew.
And there's a provision for appeal against any order of the DC, my lords.
I understood it, the order of the DC, but the DC passed any order for this order? Where's that act of 2015?
I have annexed it in my affidavit, my lords. Affidavit is there, my lord. Two affidavits fine. I have annexed it as an annexure number.
My lord, 113, page 113, section 5, my lord, is the procedure.
Okay, oh, this is the act.
Yes, well, I have annexed.
It's a 2015 notification.
Assam Agricultural Land Regulation of Reclassification and Transfer for Non-Agricultural Purpose. Well, commercial.
The procedure, my lord, is laid down in section 5.
But the deputy commissioner can't do by his own. Of
If your lordship comes
procedure
to
of an owner of area who intends to
section 4, my
reclassify or return
subsection 4 of section 5.
shall accord an in principle approval or deny approval on 40 days of the receipt of the recommendation. And doing so shall take the How much was the land?
Lord, I have stated here.
How much was?
My lord, in para 3, I have stated, my lord, in details. There.
How much was the land?
My lord, different applications were there, my lord, in respect of the.
How much did he classify? In principle.
There were total 19 numbers of applications, my lord.
How much is the land?
Yes, yes. That I have to.
And did you pay the reclassification premium?
No, that is awaited due to the my lord, cancellation.
Then what right do you have?
No, lordship, you kindly see, my lord, that letter has been issued by the my lord.
Understood, but reclassification has to be, it's an agricultural land.
Yes, but they do not accept, my lord, the premium due to the impugned order.
Understood, obviously. That order already has nullified the earlier exercise. And as such, what right do you have unless you only can ask for an application?
So what I'm on, my lord, your lordship will kindly see. My lord, the procedure.
Anyways, let us have it on some other day.
Correct.
Let us, I think the records will be necessary. Because then we will see how, in what manner it has been done.
On Tuesday, madam.
What?
Well, it was the last time they took adjournment, my lord.
Ah.
Records came and returned, my lords.
Tuesday.
He's from NHIDCL. How he knows, my lord, the records come or not?
I presume. I know a lot. I know a lot of things.
Mr. D. Gogo is a counsel for every department. That is why I'm saying he is the only counsel.
Correct. That is.
He knows everything. Mr. This court, upon hearing the learned counsel appearing on behalf of the parties and more particularly on taking into account the challenge so made to the communication, the impugned order dated 8/1/2024, is of the opinion that the records which led to the passing of the impugned order dated 8/1/2024 would be required to be looked into. It is seen that on 18/6/2024, this court had also directed the production of the said records. This court fixes the matter again on when?
Tuesday, well.
Tuesday, not possible. 6th of August.
6th.
Possible?
I'll try.
I'll try.
on 6th of August 2024, on which date Mr. B.J. Talukdar, the Learned Counsel, appearing on behalf of the Deputy Commissioner, District Commissioner Karimganj, shall ensure that the records are produced. Both the matters are same.
Same impugn order.
Always.
Yes, Mr. Vishwas.
This matter relates to notification given to us that the government wants to acquire our land under Mala project widening the road, my lord. And according.
You don't want to give it?
We want to give, but the price is so poor, my lord.
Then
3
don't
lakh
give it.
rupees is
Assam Mala.
So don't give it. Mala, by Mala project, they cannot forcefully take your land.
unless they acquired.
If they don't agree, then very well. Don't agree. Don't take it. We record his submission that if the petitioners are not agreeable with the amount, they would not go ahead, they may acquire the land. If they want to.
I'm agreeable to that.
Why do you need an order?
No, but what happened?
The
They are
Mala
not-
project is
They are
clear.
not allowing to engage our land in other way. That is the problem.
Ask for compensation for that also. Hello, let us have it on some other day.
Also, my lord, to the deputy commissioner to consider his
When
price.
should we have it? Tell me.
Any day as per your conversation.
Get me the Mala project scheme is here.
Yes, my lord. Gazette notification is there.
Is here.
Yes.
Okay. We'll do one thing. We today
Any first week of August.
this is the matter tomorrow at 2 p.m. We dispose it of tomorrow. Mr. Talukdar, you see, if they don't agree with the rate, then obviously you have to go. Only way out is for acquisition. Or whatever may be, you may or may not, that's your lookout.
So this is their choice, my lord. We cannot complain.
Wait, please, Your Lordship. Well, the petitioner started construction of his G+2 building, my lord. The approval of the GMD and GMC authorities, my lord, sanction plan and everything. All of the structure has been built, my lord. And thereafter, my lord, within the vicinity, my lord, at a distance of more than 50 meters, there is MES quarters for grade D employees. And so they were disturbing. So we are asked for that, give me a notice. Why you are stopping us from construction? Because we have the necessary permissions. They come out with a notice saying that your house is built within 500 meters. And so you cannot construct without our permission.
MES.
MES, my lord. So, my lord, accordingly, they have stopped and we have challenged it and a status quo order has been there. Whole of the structure has been built, my lord. And there has been a law with regard to this, my lord, wherein MES issued such notices, my lord. As for that law, my lord, section 5 lays down the procedure with regard to this. Nothing been followed as such. My way or highway, my lord, that way, that manner, my lord. Whole structure has been built, only the concrete walls and all things were under construction. And they come up with this, threatening us that if you start continue with the construction, my lord, there will be laws and affair against you, my lord. They threatened us. May I take your lordship, my lord? Page 38, my lord, is the impugn notice, my lord. Impugn, yes.
So status quo means you are not in a position to
I have
build.
not been here. All cement has been turned to stone. All sand I have purchased for the construction, my lord, all been gone in right.
That has not, yeah, but anyways, why? What has happened?
My lord, will kindly come to page 35 also, my lord. Here is the permission given by the competent authority, under which, my lord, sanction plan, my lord, I have constructed as per the plan. 35, my lord, 8/7/2021.
So where is the impugn notice?
Impugn notice is at page 38, my lord. Type copies from 36, my lord. My construction is not within 50 meters or 10 meters.
Yes, who is appearing for the central government?
Lordship,
What is this?
Lordship, this is done as per the SOP, Lordship, and we have never threatened him, Lordship, just we have informed him to obtain the NOC, Lordship.
NOC
Never-
from whom?
NOC from the local military authority, Lordship.
Why?
Yes, because Lordship, it is the within the jurisdiction of that particular 100 meters radius, Lordship. It's a defense land nearby, 100 meters within the jurisdiction. Lordship.
There cannot be any construction.
There may be construction, even post building, they may also construct, Lordship. Thus, they have to obtain the NOC from the authority, Lordship.
You'll give a permission, you give the NOC.
He can approach the authority, Lordship. There is no bar, Lordship, so just we have informed him to obtain the NOC, Lordship.
Hello? Let us have this matter on 21st of August. You approach, you
Lordship,
will give
Lordship.
me.
No, my lord will kindly see one thing.
Mr. Bhuya, kindly understand. You approach 7 days, let him give. I'm taking it up on 21st. If he does not give, we will look into it.
What I am on, my lord, their own circular says 10 meters away. My house is more than 50 meters away.
Then, Lordship.
And they admitted in the affidavit, my lord, with regard to this. My lord will kindly come to page 53, my lord. There is the first circular of 2011. My lord, B kindly see, my lord. Where the local municipal laws doesn't so require, yet the station commander feels that any construction is coming up within 100 meters for multi-story building for more than 4 stories. My ground plus 2. Distance shall be 500 meters. Radius from distant establishment can be a security hazard. It should refer to immediately to the next higher authority in the chain of its command. In case of next higher authority, this is the provision. With regard to 2000, this has been modified again, my lord. You can see at page 55, again modified. And the distance has been made to 10 meters.
Where?
At page 55, my lord, you can see. This 2000,
10 meters.
yes. 2011 has been superseded by 55 again. This was a 2011, my lord. 2000, page 55, my lord, will kindly see. Guidelines for issuing no objection certificate, paragraph 2A, my lord, will kindly see. It has been reduced to 10 meters. And I have constructed whole of the structure within this period, my lord.
List A is, you come under list A or list B?
B1.
Part A.
Yes.
You come under part A or part D?
My lord, part B, my lord, at page 58, my lord, I have marked it also. Kindly see, my lord,
Is it
part
part A or
43.
part B?
This is with regard to that annexure also I have, part A, my lord. Part A, serial number 43 at page 58.
Guwahati, Khantipur.
Bhutnath,
at
Narangi,
Shantipur?
Bokhisto, Shantipur. So 10 meters. And my house is more than 50 meters away.
What is B? Where is B?
B, my lord, is at page 64.
Then
Altogether
there is
different.
another
My
one.
area doesn't come.
This is where local view consultation here before appearing negotiation states view about the other defense here. Is that any construct coming within 50 meters of the defense area which is listed in here is the security hazard, it shall for the matter immediate. It's
So it was reduced to 10 meters, my lord, by them only.
Now what is up 2020?
Yes, my permission is on 8/7/2021, within this time. And after obtaining the permission, my lord, after constructing whole of the structure, my lord, they come with another, my lord, notification now, my lord, will kindly see.
So there also it is 50 meters.
They make it, my lord, 50 now. Please.
So now 50 also you are outside 50.
Absolutely, my lord. Why I will go for permission, my lord?
Even Lordship may kindly paste our affidavit, Lordship.
Anyways, we'll do one thing, we'll have it on some other day.
My lord, 29, my lord. Because of the urgency, my lord, whole.
Okay, 29, I'm not sitting anyways, let me fix it on 29.
My lord is not sitting.
No.
Any other day, my lord, as convenient to the court, my lord, I lord, my lord.
No, yeah, the construction activity is steady. We'll do anything, we'll have it on 31st. 31st, and liberty given to the petitioner to mention the matter for upgrading.
Yes, deeply obliged.
We'll take it up at 2.
Lord,
List the
deeply-
matter on 31,
indicate that to know.
taking into account the urgency expressed by the learned counsel appearing on behalf of the petitioner. The matter stands adjourned to be listed again on 31st of March 2024. Be taken up at 2 p.m.
Deeply obliged. Obliged.
41.
Yes.
Pilots may kindly peruse the last order dated 11/6/2024. This honorable court had directed the respondents in the agriculture department to submit a timeline when the elections would be held. They came up with a tentative schedule and they were directed to put it on an affidavit, which they have not yet filed, my lord.
Yes.
He's the chief for agriculture.
You filed the affidavit?
No, not.
Let's kindly have a look the order, page number 52. My lord order. Page
Huh?
number 52.
What is that?
So his tenure already over, because already
Whose tenure?
the tenure of the committee and the this petitioner.
Tenure of the petitioner?
Tenure of the committee of the Lanka Regulated Market Committee. Already disposed of, my lord, page 52. That order is 17/11/2023.
Tenure over?
Already about the
But
extended
that is to their understanding. So after that, they had issued a notification whereby an ad hoc chairman was appointed.
Huh?
After this writ petition was declared to be infructuous, they appointed an ad hoc chairman, one of an executive officer. So we filed this instant petition assailing that order, saying that no ad hoc chairman could have been appointed in terms of the act.
But anyway, there is a direction to
Yes.
this Lanka for holding that meeting when you are having this election business. Why you are not filing this affidavit?
There is a difficult.
Also regarding the holding of election, there is a election committee is there, Lordship. So they have to make party the deputy commissioner and Lordship. Lordship, can you have a look the page number?
Who submitted on the last occasion? Arbora. Who is Arbora? Yes, why you are not filing that affidavit?
This is the instruction note I have received today morning, Lordship.
Election of an hetu koi hai na. Kahi lagi boli, basi party no lagi.
हाँ.
Deputy Registrar, Cooperative Society, তাই হব লাগে, party হব লাগে.
Mr. Bulwa, we take up the matter on some other day, taking into account they have now come up with a different aspect, wherein they say that these election can't be held. Electoral rules cannot be prepared. This is the
Maybe
latest.
served a copy of that order. I also need to peruse it.
Lordship, I'll file a affidavit in the Lordship.
Then he will say that the proper authority is not there.
Lordship, proper authority, Lordship, can you have a look, page 23.
These are preliminary
Already
issues
election
that were
authority.
raised.
Lahore.
File
Petition
affidavit.
Lahore.
Focused in the Lordship.
Pursuant to the order dated 11/6/2024, whereby there was a direction to the Agriculture Department of the Government of Assam to file an affidavit as regards the schedule of elections. Miss Arbora, the Learned Standing Council today placed on record place an instruction issued by the Joint Secretary to the Government of Assam Agricultural Department, Dispur, whereby it is seen that the electoral rolls is yet to be prepared on account of various difficulties. This court keeps this communication on record and marks it with the letter X. Mrs. Arbora shall also give a copy of this communication to Mr. A. Borua, the learned counsel for the petitioner. In that view of the matter, list the matter again on 12th of August 2024 for further consideration.
Obliged, Lordship. Obliged, Lordship.
Your lordship, kindly pass over the table.
What?
Pass over the table.
Passover. Fantastic. Learned counsel appearing on behalf of the petitioner submits.
Not killed by extremists.
Huh?
Not killed by extremists.
Then wouldn't that same order be applicable today which I
Yes.
passed? So that order we passed where your senior was appearing, Mr. M. Hussain.
Yes, yes.
Then disposed of. A2. What is that number?
I'll give.
And that is why you are asking for time. Thank you. Disposed. Now, that is today.
We need some instructions from the petitioner, my lord, as we have not received any sort of allotment letter as to date. So if they kindly given us for 2 weeks, then we'll come up with a rejoinder. They have given.
You filed the affidavit?
Yes. Well, the matter related to my allotment of room, my lord, in a newly constructed building, my lord. And my lord, the municipal board has taken a resolution, my lord, to allot the room and all the tenants, my lord. 21 rooms, my lord.
And the petitioner did not get.
Yes, but my lord, they came in apprehension, my lord. They came in apprehension that they may not be allotted room, my lord.
Now, has the petitioner got it?
But we have taken a resolution on 11/7, my lord, the municipal board, that all the tenants, 21 numbers, my lord, including the my lord, petitioners, my lord. Then
You have brought on record by filing an affidavit.
Yes, we have filed a affidavit, my lord.
List the matter tomorrow. Two. Dispose it of tomorrow.
Yes, sir.
Or in this regard, my lord, just one aspect, my lord.
What?
Just one thing in this regard, my lord. Our name although is there, but we have not received, my lord, any sort of
Mr. Counsel, you are enjoying a stay. The stay I'm going to vacate. You can't enjoy a stay if you don't have instructions. We'll have it at tomorrow at 2.
this it's identical matter, my lord. Identical matter.
Identical. 44. Editor. Mr. Sharma, this is the 44 is identical. Okay. Okay. Tomorrow at 2.
Now 49 and 50, order still vacating.
May I please? My lord, this IF for vacating the interim order dated 19 to 24, my lord, passed in WBC number 8/19/2024, my lord.
We'll take it up on some other day. Matter will require, what is the matter about?
Matter regarding the removal of the chairman of the cooperative society, my lord.
Okay, we'll have it on a Tuesday or Thursday, whenever you want. Which one?
Friday, my lord.
Friday, not possible. We'll have it on a Tuesday and Thursday when we'll
Thursday,
dispose. Huh?
Thursday, because I have filed the affidavit in opposition. That has also not come on record.
Okay, it has been brought to the notice of the court that the respondents, private respondents.
I'm the writ petitioner.
The writ petitioner has filed an
filed an objection to the IA. my lord.
has filed an affidavit, a reply to the interlocutory application, which is yet to come on record. List the matter on Tuesday. 31st, 38th, no, first,
31st.
on 1st of
And-
August 2000,
Kindly after 31st.
1st of August.
Second.
He doesn't have an urgency. My goodness. We'll have it sometime later on.
In
Then
fact,
on.
my lord, as
You are
per the
enjoying a
impugn-
stay.
As per the impugn order, my lord, it is very clear that the registrar has
We'll have it sometime on 13th of August.
much.
If I orders.
Service not complete. The service being complete. The Office of the Lozima Code reveals that the service is complete. Accordingly, list the matter for admission.
7.
I'm the petitioner in 46 and respondent in 47. Actually, there was an order of the insurance ombudsman. I have filed this writ petition for implementation of that order. And against that order, the respondent company has also come.
Service complete?
They have appeared and they have.
Service complete?
Proceed.
Okay, we fix it for admission.
But if a short date may be given because I am incurring loss every day because of the vehicle. There was an accident in the vehicle. And the private company is.
Taking into account that the service is complete, list the matter for admission on 5th of August. What is this?
This is the IF for restoration of the contempt petition matter. Here
It was
on-
dismissed for default.
Yes, my lord. So, my lord, on 5/2/2024, my lord, one of my colleague, my lord, is made apparently made a wrong.
Which is the order?
Page number 23.
Huh?
Page 23.
20?
23.
3.
Yes, my lord. 5/2/24.
Means that the instant content has been issued in structures. In view of the order dated Iman past in so and so having been reviewed by the order dated Iman. So your submission is on the last occasion means it was a wrong information given.
Yes, my lord. By facing this review petition.
Okay, have you issued the notice?
Contempt petition, my lord.
Huh?
Yes, my lord.
Who is the other side? Okay.
It was under Honorak Goel.
Did the other side appear on the last occasion?
BTC, my lord. No. Two respondent were there. The Principal Secretary BTC and Vinod.
Who filed the contempt?
I'm fine.
You were the petitioner,
Yes, ma'am.
but your petition was dismissed.
Yes, ma'am.
Then?
By fishing the wrong.
Huh?
On the last occasion, my lord, one of my colleagues made a wrong submission that the review petition has been filed against the red petition of 2/8/2022.
And
against
then?
this contempt petition, but that was the different order.
Review petition filed against what?
Petition
Was against 6126.
6126, yes, madam. That was the different red petition.
Post of Lehok. The instant application has been filed by the petitioner for recalling of the order dated 5/2/2024. On the ground that for recalling of in view of the fact that on account the Discord had committed a mistake had committed an error in rendering the contempt proceedings infructuous on the basis of the order dated infructuous on the basis of the order dated 11/10/2023 passed in review petition number 194/2019. The learned counsel appearing on behalf of the petitioner submits that the order dated 11/10/2023 passed in review petition number 194/2019 is against the order dated 26/2/2019 passed in WPC number 6126/2013. Taking into account that there was a mistake committed by this court, and in view of the well-settled principle of law that that due to the fault of the court, the party, a litigant should not suffer, this court recalls the order dated 5/2/2024 passed in contempt case number 700/2022 and restores the said contempt proceedings to the file of this court. Full stop. The registry shall list the contempt case number 700/2022 before the appropriate court on such date as it may be fixed. And it will restore the file to the file of this court. Yeah, please. Contempt case number, it will list the matter on 5th of August 2024. I can allow list the matter on a contempt case. Next.
51.
This is this Kamakya access corridor case. On the last date, what had happened is because our main apprehension was, and the reason why we approached this court is that the project would disrupt the underground eternal springs which manifest in the various in the main Kamakya Garbhagriha as well as the other temples. Because it's there are 5 levels being built, 60-70 feet deep retention walls, which are the admitted feedings. Then what had happened is then the Assam government itself files an affidavit saying that they will have IIT Guwahati do the study. And on the last date, Your Lordship has the last order, I will read it out, Your Lordship, because what I'm seeing today is very limited because the Assam government's undertaking they have not adhered to, so they should be directed to adhere to that. Because they had said.
Mr. Hazarika, is everybody appearing?
Yes, everybody, sir.
Respondents are appearing?
Yes.
So we do one thing, we fix it for admission.
Yes, but what has happened is, if I may just indicate Your Lordship, just one because I've come specially for this matter. On the last date, they had said that they will file an MOU with the IIT Guwahati. Now, in terms of the statement made by the learned AG, as well as the undertaking given on affidavit, Your Lordship, I will take Your Lordship. The MOU executed does not say the undertaking on affidavit is that the IIT Guwahati will undertake the study themselves, 1. 2, that there will be no disturbance to the eternal springs, the underground, because that is the my main purpose. In the MOU that is executed. Now, again, in the affidavit, they have today filed this affidavit, which I believe is on record. On affidavit, they reiterate the same submission that the eternal springs will not be disturbed. But the MOU executed with IIT Guwahati shows that IIT Guwahati is not going to do the study. Study will be undertaken by someone else, and the protection of eternal springs is not even recorded there. So the whole assurance given to this honorable court. So my only submission, I just want to show that. So they'll be directed to explain why there is a variance between their affidavit and their own undertaking, as well as the MOU.
Okay, when are you available?
If I'm here, I'll try and be here on the 5th. I checked.
When?
5th
of August? Shall list the matter on 5th of August 2024 for admission, taking into account that the service is duly complete. Mr. E.U. Hazarika, the learned senior counsel, appearing on behalf of the petitioner, submitted that there is a variation between the submission which was made before this court
On affidavit.
which was also mentioned in the affidavit with the document enclosed. The learned counsel,
MOU enclosed, MOU, your lordship. is-
Huh?
MOU enclosed.
with the document enclosed? They have enclosed the document, no?
MOU, my guess.
The learned counsel appearing on behalf of which department?
Lordship, and for the private respondent number
No,
10.
no, who has filed the affidavit?
Lordship, affidavit has been filed by the state lordship.
That's Commissioner PWD. Respondent number 5. Respondent number 6.
Filed by the respondent, the counsel appearing on behalf of the respondent number 5 shall on the next date duly explain the
6. Sorry, 6.
duly explain the variation so shown, the variation so submitted, the variation in the affidavit as well as the MOU on the next date.
It's respondent number 6, not 5.
6.
I'm great.
Did I mention this matter earlier? You are waiting from the morning itself?
I don't usually like to push the judge to the court on the court.
No, this matter,
And next time, my lord, now that your lordship
no,
has
it's an
granted me
order
that liberty, my lord,
matter.
I'll-
No, no, it's an order matter normally. Order matters are, see, with so many admission matters.
I know.
it's very-
No, actually, when there's substantive hearing and substantive orders, because then it's also new kind of matter which I usually don't hear. So I was quite engrossed in them. I had to revise my notes in fact before I start on. I'm grateful.